You haven't seen it? So if you go to kingstoncitizens.org, our website, there's a link at the top of the page, and you'll click on that and you'll go. It's a dynamic Google Doc. It's live, and what we have been working to try to accomplish is to understand the initiatives of the Trump administration, to outline their context, and then to really get into the nitty-gritty to do the best that we can to identify policy and laws that are both state, county, local, wherever we can, to start identifying the checks and balances and safeguards to create a baseline of understanding and to turn our attention away from the national political, what should we call it, the conversations that are national, that are important to be, of course, in touch with, but to start looking inward to our local community and understanding how government works locally and statewide, which is empowering and inspiring. So we started this document. We had a few small meetings. There's 30 or 35 initiatives that cover many subjects. It became too much to do in a 3-hour setting. So what we've gone and created was a series to focus on issues that really correlate with this Trump document. In the future, we'll be projecting it so that you can see it, and we can be all working in real time where we're looking at it. We're looking at the initiatives that we're actually directing our conversation to and identifying the areas to go to research throughout or after, because the goal is to get as much of the information that we can into the document for the citizens to have a baseline and more of a conversation that helps us, that's factual, right? So that's the gist. We do have a newsletter. I'm sorry, we have a sign-up sheet in the back. If you could make sure you've signed it if you haven't, or if you're not receiving material, so we can keep you informed. And before, the last thing I'll no, it's okay. The last thing I wanted to say is that, so Kingston Citizens has this series, these community forums focused on Trump initiatives and New York State laws and policy. But for your information, we're doing a second series this year on government, on local government, and we've already just booked our first one on charter reform with Dr. Jerry Benjamin and Jennifer Schwartz-Berkey. We're going to do another on SECRA, which is the State Environmental Quality Review Act, and others. So we're getting all kinds of series going on here. We're lumping them and trying to make it as clear as possible. There's a lot to discuss and a lot of different ways of looking at our local government. So that's coming up, and that's not to confuse anyone, but that is happening on July 13th. And the On Government series is going to be at the Kingston Public Library, so that we have distinct places to be working. So I want to move forward here and say today our first panel, our panel discussion is on constitutional law. Now, I'm going to let Lynn take it away, but just to introduce, I want to say that Lynn is an associate professor of political science at Marist College. My name is Rebecca Martin. I'm one of the founders of Kingston Citizens, and I am moderating today, and this year. So, Lynn, I'm going to just read this straight off your handout as well. Lynn is a political science professor at Marist in Poughkeepsie. She earned a bachelor's degree from Gettysburg College. I'm going to short form it.
A long time ago.
In 1992.
Yeah.
That makes you 20.
Yes, that's
right. So she has a doctorate from the Maxwell School of Citizenship and Public Affairs at Syracuse University. She is also the Alderwoman of Ward 1 in the City of Kingston. This is her first term, and she's been an incredible advocate for the public and has done great work for us. Her partner is Amy Eckert, who's a writer and comedian. And they have 3 children, and they're living in Uptown Kingston. So when we first started this work, Lynn and I spent, I think, 3 hours on the phone trying to undo the context of some of the Trump initiatives, which we can get to later. The constitutional law, I just wanted to say, deals with the fundamental principles by which the government exercises its authority. And I thought this would be an excellent way to start this series, to give people a sense of the relationship of the different entities within a state, namely the executive, the legislature, and judiciary. So let's start there, and you're going to present. So Dr. Lynn Eckert.
Pitch this at a pretty basic level. I know I have some people here who could stand up and speak about this and not need me, and other people maybe know a little bit less. For some, it might be a review. But the idea here is to really look at the Constitution of the United States and to figure out how it constrains Trump, essentially, how it constrains really any president. And so in doing that, I'm going to look in particular at Articles 1, 2, and 3 in the United States Constitution. The first article deals with the legislative branch, the second with the executive branch, and the third with the judiciary. And then I thought we'd take a look at some of the amendments to the Constitution that will also, I think, figure prominently in constraining Trump. And there I would point to the 10th Amendment, and I would point to the 14th Amendment, in particular when it comes to civil rights and liberties. I'd look at the Due Process Clause in the 14th and the Equal Protection Clause. So that's kind of just an overview of how we'll step through it. I also want this to be really informal. This is old school. You know, usually now we have PowerPoints and, you know, all of this stuff. So this is just me talking. And feel free at any time to interrupt me, feel free to ask questions, feel free to challenge me. That too can be part of the fun. I think one of the things that I wanted to start off in talking about the Constitution, you hear this in debates all the time. We were debating about sanctuary city, the issue of the Constitution, what it says came up. And I just want to point out right from the beginning about the Constitution. The Constitution is not like a European code, you know, where everything is spelled out. There are abstract principles embodied in the Constitution, and the Constitution requires interpretation, right? So once you get into interpretive territory, you can't say, you're going to hear this, right, because we have a new Supreme Court appointment. And one of the things that really drives me crazy, and I talk to my students about this all the time, is when someone gets on the TV and says, we like this guy, he's going to strictly interpret the Constitution. Drives me insane. That's not possible to strictly interpret the Constitution. You can look at something like the First Amendment, which has pretty absolutist language, right? It says Congress shall not abridge free speech. We abridge speech all the time, right? That's not really the question. Commercial speech is abridged and regulated, obscenity, sedition, right? So that's not really the point. The point is what values and assumptions are operating in the background to give meaning, to give life to these rather abstract principles, right? So I want to say that first off. I mean, there are just innumerable parts. I would ask, too, how do you strictly interpret the Ninth Amendment to the Constitution? If you were to take a look at the Ninth Amendment, you see that it essentially asks you to find values that are not specifically listed in the Constitution and to protect them, right? In fact, one of the reasons that James Madison was really reluctant to add a Bill of Rights to the Constitution was that he was fearful. First of all, he said, we have a government of limited powers, right? And he said basically it's superfluous to start saying what the government can't do, because if a power is not granted to the United States government, the national government, they may not use it. He eventually realized he was going to have to compromise with anti-federalists, and he said, okay, I'm going to start listing these amendments, these part of the Bill of Rights, but he said, look, I'm going to include the Ninth, because my fear is that as I start listing these specific rights, if I forget one, you're going to think it's not fundamental and it need not be protected, right? So that's just we should keep that in mind as I start to work through these different articles, that there are interpretive debates ongoing about the meaning of the Constitution that's natural and appropriate given the abstract principles that it contains, right? It's not, again, a European code where specifically you're told you can do this, you can't do that. So that's kind of the context in which we're operating. So let me begin just by sort of stepping through. I think one of the things that we in American national government study, when we look at the presidency, we call it the expectations gap. And really what that means is the president goes out, campaigns, makes all of these promises, and can't follow through, right? And one of the reasons why, and it doesn't matter what president we're talking about, it happens with Obama, it happens with Bush, whether you like the president or you don't, it happens with Trump, right? And one of the things that happens is that the president runs up against the Constitution of the United States, right? This is a system of separation of powers, and it's a system of federalism. Okay, so these are the other broad points that I want to bring in before we start to get traction and look specifically at these articles, right? So you have to understand that separation of powers and federalism undergird, they're the foundation of the entire Constitution. And what that means is, historically speaking, the way we understand separation and federalism is that, you know, the framers of the United States Constitution had a very bad experience with centralized power when dealing with Great Britain, right? So their reaction was to create a government that didn't have a lot of powers at the national level. That's what our first Constitution of the United States looked like, the Articles of Confederation. And it wasn't a big success. It was a big failure in many, many respects, right? The national government didn't have enough power to act. And for those of you who study American history, you remember Shays' Rebellion, right, which really drove home the point that this Constitution is generating economic and political instability. Shays' Rebellion, again, we had a hard time putting it down, right? It occurred in Massachusetts because the federal government didn't have enough power to act and pull troops together and go and put down the rebellion. So after that experience, right, we decide we need a new, well, we don't decide actually we need a new constitution, we say we're going to revise it, right? If you really want to be technical, legally technical about the United States Constitution, it begins in a moment of illegality, right? Because all they were authorized to do when they went to Philadelphia was to revise the articles, instead they scrapped them, right? And incidentally, that's why we've never had another national constitutional convention, because they can be runaway conventions, and you can start out wanting to revise one element and get rid of the whole thing, right? So at the national convention, right, the animating question was, I would say, I mean, there were many questions, but I'd reduce it to this one. The animating question was, how do we give the national government enough power to act, right, so that we avoid our experience with the articles, and yet not allow a concentration of power so that we don't repeat our experience with Great Britain. And one of the ways in which we decide that we're going to give the national government more power, but we're not going to concentrate it, we're going to disperse it, is through separation of powers, right? So when we look at Article 1, 2, and 3, the architecture for separation of powers is right in there, right? And essentially what separation of powers does is it makes it difficult for any one branch to act alone. Right? You need cooperation. This is the correlated principle of checks and balances. So in a whole host of measures, for example, Congress passes the laws, but the president implements them, but the president has the power to veto those laws. Those laws, the veto can be overridden by 2/3 in both houses. So again, the president just can't kind of come in and say, we're going to do this, and Congress goes along and follows. And you'll see as we step through these different powers that are granted each segment of government, as well as the checks that are given to them to check the other branches, make it really difficult for anything to get done, right? What our system of separation of powers really does is protect the status quo, right? This is one of the fascinating things about the Affordable Care Act, right? It may not have gone far enough for some of you, may have gone too far for others, but it was fairly, and we can debate about this. Randy here is a historian, so he might challenge me on this, but it was fairly comprehensive and unusual in the American political system at a time to have that kind of policy change, right, occur in a context where there wasn't a crisis, right? We're not talking about the Great Depression, we're not talking about a world war, right? We might have had a healthcare crisis to some extent, but we're not talking about on the same scale. Right, so the point I want to telegraph to you, the point I want you to take away is that with separation of powers, change is really, really difficult, right? And even if you've captured all 3 branches of government, or all 2 branches of government, if you want to just think about the presidency and Congress, it doesn't matter, right? Separation of powers is still a brake, right? It's still meant to slow things down. And in fact, a hallmark of the political system in the United States, the policy-making system in the United States, is incremental. And you get incrementalism in a way that you don't get it in, say, a parliamentary system. Right? And there are reasons because the parliamentary system is structured in a very different way, and you get more coherent policy. There are bad things, you could argue, that come along with separation of powers, too. If you want comprehensive change, you're going to have a hard time getting it. Right? Maybe you want it. Accountability is really difficult to get, because in order to get majorities, to build them both in the House and the Senate to get a law passed, and then have it go to the president and not have the president veto it, you got to make compromises, right? And they're ugly. You know, the old metaphor about lawmaking in the United States, it's like sausage making. You like the sausage, but you don't want to see it made. You're not going to want to eat it, right? And so I think the same thing is going on, and that's in part, an element of separation of powers. So let's focus for a moment on Article 1, right? And we'll circle back around to federalism, which is yet another check, I think, on the national government's power. And what I would say about federalism, too, is that historically we've heard federalism discussed in terms of states' rights, for example, and states' rights are often, conflated, I think, sometimes historically inaccurately with racism. Not to say that it hasn't occurred, it absolutely has occurred, but there have been also instances where states' rights have been invoked as a way to fight racism, too. But that is also its history, right? To link states' rights with conservatism and to link it with racism, really. But there's a new movement afoot, and many argue that progressives need to take back federalism as a way to check the power of the national government. It's being named progressive federalism, and the sort of tagline is, "It's not your father's federalism." So there you go. And we can talk about that as well. Another way to disperse power and keep a check on the national government. Okay, so let's think about Article 1 here, and you keep me on time?
Yeah.
So Article 1, when you look at it in the United States Constitution, is the longest article. And it was deliberately meant to be the longest article by the framers of the Constitution. And that's because they believed that the legislative branch was going to be the dominant one, that it was going to dominate the executive branch and the judiciary branch. And so, they created a bicameral system, right, in part, again, because of a compromise over representation, but also as a way to check the power of the legislative branch so it wouldn't predominate, it wouldn't overrun the other branches. And that's important too, right? Important in terms of how it can constrain Trump, right? Because you have these 2 different houses. You've got the House of Representatives, as you guys know, 2-year term, right? That might be terribly problematic in a lot of respects, right? Because they get into office, it's only a 2-year term, and they're already thinking of running again and building their war chest. But it's also, there's a great deal of turnover, right? So Faso, he's not holding these town hall meetings. He's going to have to run again, and in a very short period of time, he's going to have to face the music. I think people are going to be pretty angry about it, right? So it's a 2-year term. The constituencies are different. Who elects you is different from, say, the Senate. And who elects you, again, a smaller legislative district. And there's a lot of talk right now. This is another area where I think some activism at the national level is really important, is about gerrymandering, right? It's about drawing these districts so that they're safe for a certain political party. And it has the effect of making our politics more extreme, right? Because you're packing Republicans into one district. And in the way that our primary system works, they tend to be more conservative, right? And they get to Congress, they're representing a more conservative constituency in a way that really doesn't reflect, I think, overall, the political positions of most people in the United States. They tend to be more moderate. So gerrymandering is one area. And the Supreme Court of the United States has kind of, they have, initially they didn't weigh in. They said it's a political question, so we're not going to weigh in on it. And then eventually they did. In this famous case, Baker v. Carr, they have, when it comes to racial gerrymandering, if you see it from one perspective, or majority-minority districts, if you see it from a different perspective. But there's plenty of room. Gerrymander or redistricting takes place at the state level. And so I think, Governor Cuomo has made an effort to move to a bipartisan committee system that would redraw these lines in a fair way, that would bring together Republicans and Democrats in a district. Okay, so I've gone off on a bit of a tangent, but gerrymandering is something we should think about perhaps and talk about. So the constituencies are different in the House. That's really important. The term is different, right? In the Senate, it's 6 years, right? So you have a longer period of time. The rules are different in the House and the Senate, right? The Senate was designed deliberately to be a more deliberative body, to be a more thoughtful body. And the way it's functioned throughout American history is often to put the brakes on the House of Representatives, which tends to be more reactive. It's closer to the people. The way in which the House was initially elected was always through popular election. Not the case with the Senate. Initially, the Senate, it was state legislators who voted for a senator. Eventually that changes. I think it's the 17th Amendment. I don't know. Some of you guys probably know the Constitution. You're like, some...
1915.
Right, there you go, Rain Man over here. He's a history professor. So that's unfair. So you've got different periods of time. There are also different rules, right? You guys have heard about the filibuster in the Senate, which is there's a right to recognition in the Senate. Every senator gets to stand and speak, right? That right does not exist in the House of Representatives. In the House of Representatives, when you're considering a bill and you're debating a bill, any bill has to go through something called the Rules Committee. And there are limits on the types of amendments that you can introduce, and there are limits on the amount of time that you can debate the bill. So it's a different procedure matters enormously in the House. And if you've mastered procedure, you can get away with a lot in the House. In the Senate, it's a little bit tougher. It's not that procedure isn't important, but every senator has the right to be recognized, to take the floor, and to speak. Now, a filibuster is literally when you speak a bill to death. You just speak and speak and speak, and you prevent action, and a compromise has to be made, is, I think, the end game of a filibuster. There's something called cloture, where if you get 60 votes, a supermajority in the Senate, you can shut it down. There's been a great deal of talk, right, about changing this old tradition in the Senate and getting rid of the filibuster. It's called the nuclear option, right? Some say, well, let's just get rid of the filibuster when we're talking about voting on judges to the federal court system or justices to the Supreme Court, right? This is an area where appointments to the federal courts, particularly the Supreme Court, has become very politicized, right? This goes back to Bork, Robert Bork, if you remember Bork. It's now called, the expression is you get borked, right? So one of the ways to do an end run around this is to just get rid of the filibuster. So there's some talk about that. But again, the sort of main point that, again, I want to telegraph to you is that the Senate is a different body than the House. It tends to be more conservative, and it tends to rein in the House of Representatives, whereas they are reactive. They're supposed to be closer to the people, right? In the Senate, you have 6 years. You make a decision that you believe is in the public good, but is politically unpopular. You got quite a bit of time to get to your constituency and convince them otherwise. It's not true in the House, right? So you've got these different, these two different houses that function differently, that have different constituencies, and again are designed to slow the process down. Yeah?
Can you distinguish between constitutional requirements and traditions of the houses?
Yeah, the rules, parliamentary rules.
Can you repeat the question, please?
Yeah, the question is, what's the distinction? There are there are rules and traditions versus constitutional principles. So the filibuster is nowhere mentioned in the United States Constitution. It is purely a procedural matter, a rule that's introduced in the Senate. And, again, I'm going to point to Rennie or maybe Joanne, but Thomas Jefferson is the one who writes the rules for, I think, both the House and Senate. So the filibuster is not a constitutional principle in terms of constituencies, time in office, different obligations. The House has the power of the purse, which is tremendously important, right? The Senate confirms the appointees the president makes to, for example, the federal judiciary. So they have different outlooks, different obligations, and that creates tension, right? Even within the legislative branch, a tension that can slow things down, even if the House is controlled solely by Republicans and the Senate is controlled solely by Republicans, right? So that's just kind of an overview of Article 1. If you have questions, we can delve in further. Article 2 deals with the President of the United States, and Article 2, I think, is in a way the more fascinating article because it doesn't say much. Right? Here we're dealing with the most powerful person arguably in the world. And there are vague clauses in the United States Constitution that give the president power. What we know in terms of separation of powers and the architecture of Article 1 and Article 2 is that the president implements the laws. Right? The president has at his disposal a whole host of bureaucratic agencies, like the executive office of the president, right? The president's cabinet. The president's given some enumerated powers, which I should step back and mention as well for a moment about the Article 1 and the legislative branch. Just like the president in Article 2, there are some enumerated powers explicitly given to Congress. You can find those in Article 1, Section 8. And every single one of those powers, particularly something like the power to regulate interstate commerce, is open to interpretation. We have historically thought and argued about what constitutes commerce, for example. You can have a broad definition, you can have a narrow definition, right? The same is true with the executive branch and the presidency. He has some enumerated powers, so he's commander-in-chief. That would be an example of being an enumerated power. And he's given really broad power to run the armed forces, right? He has pardoning power, right? He can pardon. That typically doesn't happen until the end of a person's term, right? Because pardons can be tremendously controversial. He is given, what else is he given? Again, I think I mentioned before, he's given the power to implement, right? The laws that are passed by Congress. So he's got a veto power. He's got a wide range of powers. Those are enumerated powers. I think he also has delegated powers. So delegated powers are those powers that come from trying to implement the laws. Congress often will pass a law, like the Affordable Care Act, and it's very abstract in general. Right? It really doesn't tell us anything about how to actually implement it. So the president will get that law, right? And through the delegation of powers, he will implement it and determine what it means in practice. That's a great deal of power. There are some limits on it. There have been some constitutional law cases where the Supreme Court has said you're delegating too much. You got to pull back, right? You're violating separation of powers. But for the most part, the president, through the delegation of powers, has some broad powers to determine the meaning of the laws that Congress has passed. I think the one area in which historically the president has had the greatest powers is in the realm of foreign policy. And in particular, we're looking here at the category of something called inherent powers. Now, these inherent powers are the sorts of powers that got George W. Bush in trouble and created a great deal of controversy. Right? In particular, George Bush. Now, inherent powers are nowhere explicitly mentioned in the Constitution. You're not going to find the phrase inherent powers, right? They are literally supposed to be powers that adhere in the very nature of an executive office. right? So you've often heard the phrase, the Constitution's not a suicide pact, which essentially means if I need to step outside the boundaries of the Constitution as President of the United States in order to save it, I have the power and the right to do so, right? In the case of George Bush, he was using inherent powers, in particular a really kind of vigorous form of inherent powers. It was called the unitary theory of the executive. Right? He was essentially saying, look, when it comes to foreign policy and when it comes to fighting terrorism, I too, as the President of the United States, have the power to interpret the Constitution, and I don't need to check with Congress. So enhanced interrogation techniques, I said they're okay. They're okay, right? So again, that's not really the nature of our constitutional system. We're supposed to have this system of checks and balances, but in the realm of inherent power, the President has been able to say, particularly when it comes to foreign policy matters, and you have to understand the context in which he's operating. It's a fearful context. This is a post-9/11 context. Historically, to the extent that presidents grabbed power, right, to deal with a foreign policy crisis, to deal with war, at the end of that war, they gave those powers back, right? And the problem, of course, with the war on terror is, how do we know when it's over? Right? So the president, and it's not, this isn't just, Bush who did this. It's Bush, it's Obama, and now Trump. You don't willingly give power back. The executive branch is taking the power, accumulating it, and not giving it back, right? So this is historically distinct and different. Now we know during the Nixon era, the phrase the imperial presidency came to pass. And some are arguing that we're in a new era of the imperial presidency, in part because of these inherent powers in the realm of foreign policy, where the president says, I'm the one who's responsible here for protecting the United States, and I have the power to interpret the Constitution, and I don't need to check with the judiciary, I don't need to check with the legislative branch. So that's one area in which I think we have to be very careful as we look at the president and the presidency. What I want to tell you is that I started saying that the framers believed the legislative branch was going to dominate, and that they had to be careful in the way they structured it to check power. Most scholars would look at the presidency and say, now the problem, the branch that dominates all the others is the executive branch, and we've got to be careful about it. But what's fascinating, the kind of paradox about the notion that the executive branch, if we want to call it imperial, let's just call it imperial for the purposes of our talk, if indeed it is imperial, the fascinating part about it is that there has not been any addition to the text of the Constitution in Article 2 since the framing of the Constitution. There's been one exception, and I know you guys all know what it is, right? It's term limits, right? It was passed after FDR. But there's been no language that in any way gives greater power to the presidency of the United States, and yet we say, look, this is an imperial branch of government. So the curious questions becomes how? How does this occur? That's a paradox. And the framers intended the executive branch to be an administrative post, largely, right? So, one of the things we do as political scientists is try and figure out, well, how did the executive branch become imperial under these circumstances? And, the argument is, and when you hear this, you'll immediately think of the way in which Trump uses the media. One way, it's a phrase developed by a famous political scientist, is to say that the president can go public. Going public, it's called. And it's the president's ability, right? The president's one person. When you look at Congress, many, many people, right? 535, am I right about that? Many, many people in Congress. So it's hard to hear one unified voice out of Congress. It's far easier to have a press conference in the Rose Garden, hear the president speak, and the president, by directly appealing to the public, who then gets angry or motivated and turns around and contacts their constituents or their representatives to put pressure on those representatives to vote his or her way.
When did the bully pulpit term come into effect?
Teddy Roosevelt.
Yeah, that would have been Teddy Roosevelt. In a way, going public is a version, a kind of modern version of the bully pulpit. And of course now, you could even say it's on steroids, right? Because Trump doesn't even trust the media, so it's not even a filter. Historically, the media has needed the president has needed the media, right? In part to get his message out. Twitter allows him to avoid, right, that middle position where his arguments, his ideas, his facts are vetted, right? So now he uses Twitter and he directly appeals to this this angry public, and they're motivated to respond and to act. Another way, again, that we, as I mentioned, inherent powers are enormously important, but also things like executive orders, executive agreements. You know President Trump has used many executive orders, and they basically say, what he's doing there is he's saying, look, I'm going to tell you what this law means, and this is how I'm going to implement it. Now, they don't have the status, executive orders don't have the status of law, and they can be overturned. But don't kid yourself, some of the most profound changes, right, in law have come from executive orders. The military services were integrated as a result of an executive order. Affirmative action starts out as an executive order. Don't ask, don't tell was an executive order, right? So executive orders have this historical place, and they do affect policy, right? And they're important to take a look at. And again, they're a way to subvert separation of powers, right? Because the president is saying, this is how I interpret the law that you passed. See you later, I'm going to go implement it, right? Executive agreements are a little bit different than executive orders. They involve negotiations between two foreign powers, right? So most of our military bases around the world, in Saudi Arabia or elsewhere, are negotiated through executive agreements. You might say, well, what about treaties? But treaties require a supermajority approval in the Senate. And to avoid that hassle of having to go and build a majority, a supermajority in the Senate, not just 51, but 60, you sign an executive agreement. And that executive agreement enables you to have a base wherever without a longer discussion about whether we should have bases there, right, as a matter of our constitutional system. So these are important. Signing statement would be another way. Signing statements became particularly popular around the time of Reagan. So these are all ways that are, we call them extra-constitutional. They're outside the Constitution, and they're ways that the president aggrandizes power, accumulates power. Now, if we go to Article 3, that is the Supreme Court, it's the judiciary. I'm going to mostly focus on the Supreme Court, federal courts. Just a few issues as we look at Article 3. One that comes to mind immediately is the power of judicial review. Right? This is an enormous power given to the United States federal court system, and it essentially says that any democratically passed act, right, any act of any of the other, I should say, democratically elected branches of government can be overturned as unconstitutional if the court says that these acts violate some principle in the Constitution. Enormous power. And there's enormous anxiety and hand-wringing about that power. I can't think of, Joanne, you might be able to correct me, but I can't think of any other industrialized Western nation that gives its courts the power of judicial review. Right? So it's this enormous power. It's it was a power that anti-federalists right away said, whoa, this isn't good, right? And of course, I think it's Jay who writes 78, Federalist Paper number 78, and he says, don't worry, the judiciary branch is the least dangerous branch. It'll be fine, right? That's essentially what he's saying. He sort of steps through as why that's the case. And you can see it either way, right? One way you can see it is to agree with the anti-federalists and to say this is anti-majoritarian. These are 9 unelected, lifetime tenured justices who sit on the court, right? They don't even, when you study the court, they don't even... PowerPoint! Actually, it might be good to put the Constitution up. Yes, to see the text. Wow. This is going to change the whole nature of the talk. It's going to get better. I'm sorry for one. You want me to wait?
Just 1 second. I just wanted to say, if you have your computer and you want to get on Wi-Fi, is that possible, Peter and Julie? Is there a passcode? Okay, they're not here. We'll check back in a second.
Sure, okay.
They might have the Wi-Fi.
Can we get on?
Yes.
Yep.
Maestro.
What is it? Maestro is the something.
Everybody's Maestro 108, 108, 10.
What? 108, 108, 10.
Maestro 108.
I'll put it up for you in a minute. 108, 108, 10.
So I just realized I've been talking for quite a bit.
No, it's good.
And that's the dilemma of being a professor. I got a lot to say. So I'll try and wrap this latter part up so you guys can interject at any point. So the power of judicial review is enormously powerful. It's not that you're not going to find the phrase judicial review anywhere in the Constitution. In fact, that power is articulated in Marbury versus Madison. And I want to say it's 1803. Rennie, am I right? Close. Okay. It's John Marshall. So it's like you can Google me. This is what it's like in the classroom now too. Am I right? No. Most of the time I'm not. Okay, well there you go. That sounds like good rationale. Maybe 1807. I think you think it's later. Okay. Joanne, just call it. Do you know?
No.
Oh, I thought you were saying 1813. Did you want to ask your question?
I did.
Yeah, please go
So
ahead.
how do these things that are not in the Constitution, how do they get power? Like the judicial review?
Well, so in that case, it's a very famous case, and it's kind of, talk about outcome determinative. We get really upset, that justices are trying to decide cases based on policy outcomes, not based on constitutional principles. That's all about outcomes-based jurisprudence. But essentially, the argument is that it's in the logic and the language of the text, and that it was a tradition that was, that was in application prior to the passage of the United States Constitution at the state levels and at the level of charters, for example, throughout the colonies. The argument in Marbury versus Madison is much more theoretical, and I could go down that path, but I think you'd all start throwing stuff at me because it's kind of, but essentially, what Chief Justice Marshall says is, look, I'm not reading my own views into the Constitution. I'm just looking at what the sovereign said in the Constitution, and I'm telling you, you can't violate the sovereign's will, right? Because the Constitution, remember, we have two different levels of politics. There's like ordinary politics, and then if we want to amend the Constitution, we have to speak in our sovereign voices. We have to act in a sovereign capacity, and that's a different kind of extraordinary level of policy making or rules that have to be put in place and procedural hurdles that have to occur in order to speak in our sovereign voices. So he essentially says, look, it's our job as the judiciary to interpret what the sovereign says. So we're not a super legislature. That makes it sound like we're anti-democratic. But we're best positioned to tell you what the sovereign says. And the sovereign says, this law that you've passed is unconstitutional, right? It's actually a masterful decision because he wants to avoid a front-end confrontation with Thomas Jefferson. The court, unlike the other branches of government, Congress has the power of the purse. The president has command of the military, and what does the judiciary have? The judiciary basically has power of judicial review, but presidents have said, like Andrew Jackson, really that's your decision, have fun enforcing it, right? And they're like, oh my God, whatever else Nixon did, when the court said turn over those tapes, he did, right? He could have caused an enormous constitutional crisis by saying, no, you come get some, right? So all the court has is the power of its reasons, right? And we respect those reasons. We may disagree with them. And the Constitution itself, when you really look at it, is a document designed for arguing, right? All you have to do is look at the power to declare war, right? That's given to the legislative branch. Congress declares war. But the ability to fight a war is given to the president. And there have been a whole host of instances where we fought a war but haven't formally declared war. So how do we understand that? Is declaring war simply a diplomatic state, right? But the actual function of war can occur with or without declaring that diplomatic state. So there are just, throughout the Constitution, littered throughout the Constitution, is ambiguity. Right? Language is not precise.
In the beginning, that it's really interpretation.
Yeah, I mean, sometimes at the college level, I'll sit on academic committees with mathematicians, and we have this college handbook that tells us the rules of the institution. And they always are like, well, just word it more precisely. You know, I was thinking to myself, I'd be out of a job if you could actually do that, right? This is about interpretive matters, and language just falls short in many instances. Yeah, Brad?
So Lynn, thanks a lot for getting us all really excited about the Constitution.
You sound like my students. They have the same level.
I'm just wanting back to Article 1 again and Section 9 that has the emoluments clause. And it's just a hypothetical out there. So the Republicans are controlling all branches, let's just say.
Right.
It's going to take them to get to a tipping point on viewing this president as the first president we've ever had that has hotels and businesses and brands and international and can be influenced on any number of levels. What do you think? I mean, since the Democratic Party can't really, they can push as hard as possible to take the Republican control of the legislative branch. You come to a point where there's a threshold moment where they say, okay, we really have to do something about this. So do you have any thoughts or suggestions or ideas about what folks in this room and just in general can be done to help coax the blue and the red and the purples to help our representatives in Washington go down that path?
Yeah, I mean, in part, the good news here is that historically, going back to the Bush administration and dealing with Guantanamo Bay and terrorism, the judiciary really did function as a bulwark. It said, stop, you can't go any further than this, right? So I think in some of these instances, the judiciary will do its job, right? The problem is the judiciary is a passive body, so it's got to wait for cases to be challenged to come to it, and then it can accept and review. In terms of people like Chavez from Utah, I was just reading the other day that what he wants to do, right? He's not willing to investigate conflict of interest issues with the President of the United States right now, but he wants to go back to Hillary Clinton, and he wants to look back at an aide who helped set up that server and to determine whether or not this criminal charges can be brought against him, right? So this guy is, politically tone deaf, right? And I think what's happening, I don't know. Basically, what's going to happen. So you're going to have constituents put pressure on members of Congress. There's no other way. Going to FASO's office and standing out and saying, why aren't you meeting with us? I've got questions, right? Rennie and I, as elected officials, have talked about going there ourselves and being like, I think you got to meet with them, And the more you can do those sorts of things, eventually it's going to have an effect, I think, an influence. At some point, you can't not be heard. Now, this president is, most presidents who are elected without the majority of the vote, who have a popularity rating of hovering around 39%, I think right now, if I'm not mistaken, who had a huge protest like a day after their inauguration, would say, in order to govern, I understand how separation of powers works. I got to start to work with people, and I can't put in these extreme policies that appeal to my base but don't appeal to anyone else, or I'm not going to be here for very long, right? And by the way, members of Congress aren't stupid, right? They're going to start to test the political wind. They're going to start to see that it's shifting, and they want to stay in office, most of them. So that if they can be gotten at through, I think, political pressure and through hearing their constituents and their outrage, right? But it's got to be consistent, and it's got to be in their face, right? And so, I think that's the bottom line. There is a court case involving the emoluments clause that was filed by people like Zephyr Teachout and a couple of other university professors. We'll see where that goes. There's all sorts of language in that clause that needs to be interpreted. I mean, and we don't have a great deal of precedent. We have this common law tradition. We don't have a lot of precedents regarding it. Yeah.
So then that clause, I'm going to talk about that later. but
Sure. No.
That clause, relates to foreign powers, foreign states, influencing us by gifts and emoluments and so on. And who knows what that'll turn out to be. If it ever gets heard by the courts, it may get thrown out, but I'm standing. But the question is there anything in the Constitution that prevents the president from making money by being president? This is what he's doing. And his whole family from making money by being part of the family.
There's not. And, this is an enormous oversight.
We never thought it would happen.
No. I don't think the framers ever could have anticipated this.
So I just wonder, what do we use as pressure for pressuring class or pressuring anybody? What's the focal point? Is it to say, this is just bad? It's just obviously bad? Or is there some law against it? I'm a lawyer, and I don't know a law against it myself.
So, did everybody hear that question?
No.
So the question, do you want to reframe it? Lynn, so we can hear?
Well, the question essentially is, I think you're asking, what's the point of law? Why do we press Basso on saying the point of law is blank and he's violating it, do something about it? And I would just say this, actually, I have this seminar right now where we're dealing with the issues of law and
Lynn, I'm sorry, I just want to include that specifically, I think this is a question for everyone, is there a law in place that prohibits a president from profiting as president on the job? And Lynn is saying no.
The emoluments clause, yeah.
What's the difference between the Constitution and a law? Is the Constitution a law, or is the Constitution the basis of law?
It's the basis of law.
Constitution is the Constitution. There's only one. It's a unique animal. It was adopted to form the country, form our government, but the laws are passed by Congress.
And if a law is in violation of the Constitution, the law is...
Right, so to say something is illegal is not the same as saying it's unconstitutional.
It could be. It's a different phrase, but it's the same effect.
If a law is in place, it is consistent with the Constitution, right?
Or should we?
Excuse me, what is the federal conflict of interest law in that case?
That's a statute. That's a federal law, right? And it's based on the government's power to pass laws, such as the federal conflict of interest.
So listen, so everybody can hear. As we're firing off questions, we have to project or reframe so everybody can hear. So what was the question that you just asked?
Okay, the question is, I just read something in the Atlantic saying that there's of course a sticky matter of the federal conflict of interest law, which prohibits officers of the United States from participating in any governmental action in which they would have a financial interest.
So that would apply to Rex Tillerson, his Secretary of State. It would apply to other officers, but not necessarily the President of the United States.
Your point about any other president who was elected because of the Electoral College and obviously has an approval rating that is fairly low. And the other points you made just emphasize why it is that Trump is going after the press. I mean, people work in this country, they raise families in this country, and they don't necessarily follow the political winds and things that are being done like some of us might. And they get their news from the press. They get an idea of what's happening with our country. And so if you can depress that, and that's why he's doing it. I mean, these are very, very smart people. I mean, Ben is a very, very thoughtful guy. And they understand that going after the press has its disadvantages, but for them, it's crucial.
Yeah, don't forget though, Bannon is also behind, he's some hubris, right? Being in the business world is not being in politics. Political experience is not the same as business experience. You don't get to go in there and just say, this is what I'm going to do, and I'm going to do it. Right? You're dealing with different branches of government that can't be fired. In addition to that, can mess up your agenda. And here Bannon writes this executive order without talking to anybody. That's moronic, especially when you have no experience in federal government, not any. To just sort of write this, it has to be implemented, right? There's a question of its constitutionality. I mean, on other measures, right? Like I might be outraged by the Trump administration, but other measures, if I separate myself from the policies that they're talking about, just in terms of procedure and the way they're behaving, it's not going to be good over the long term. And in addition to that, yes, the Republicans have the House, the Senate, and the presidency, but he's not a Republican, right? He's an outlier. And on things like infrastructure, the wall, right? You have deficit hawks who are Republicans in Congress who they're not gonna go along with this wall. It's an unbelievably expensive wall. It's gonna add to the deficit. So he's gonna run up against his own party in addition to separation of powers. I would argue, he doesn't understand the political constraints in which he's working. You know, I've heard him say things about gay rights, for example, and he'll say, oh, well, same-sex marriage was already decided. We're not gonna revisit that. Without any acknowledgement that who he places on the Supreme Court will make that decision, not him, right? And right now, we've got this guy who's gonna come onto the Supreme Court. He's relatively conservative. He's replacing Scalia, so there's no overall change. But the next appointment is gonna be enormous. Right? And there's nothing in the Constitution that says we have to have 9 justices on the Supreme Court. Early moments in history, it was 5, other variations of it. So what I'm arguing here is he's got a constitutional context in which he has to work. Can he do harm? Yes. Will he do harm? Yes. But this is a porous system, and if you know how it works, you can press the right levers and you can make it really difficult, which is what the Tea Party did and is what progressives have to do. Right?
Before we get into questions,
oh, I didn't get to the amendments yet. I promise I'll promise I'll wrap it up really quickly. Yes.
Speaking of pressing the right levers, you mentioned going down to visit, for example, FASO. What would be the optimum way to do that? I mean, we all have, I gather most of us in this room will have many issues that we're apoplectic about regarding the administration. And, do you go, is it more effective to go down with one, like the ACA or monuments, or is it something like you go, and is it effective, it's not effective to just go one person, it's good to go with a group, right?
Yeah.
And the group has to represent something larger, so it gets a little scared, I assume.
Yeah.
Anyway, I'd like your advice because I'm new at this.
Well, and people, here again, when you talk about politics, I might have a PhD, but who cares? It's like, if I were an electrician, you'd ask me how to put the plug in, and I could tell you, and it'd be okay. But on political matters, we're going to disagreement. And so your own, perspective could equally weigh against mine. It seems to me that I think it's too early to worry about having a particular issue and all organizing that issue. I think there are a lot of undifferentiated issues. The point you want to make is that you need to talk to. Right? He has to have the town hall meeting.
Also say something, which is that what I'm always curious about is what their obligations are based on whatever rule book they're following. Like, do they have an obligation to meet with constituents on a regular basis?
Not constitutionally. No.
And if they don't, should they? And could that be something that could be worked upon in the long run? Because what we're doing continually is putting out fires when we've got to get to the root of what the problem is. And you see that in local government, where there's really no obligation for an alderperson to meet with their constituents at all, but they have to sit on a lot of committees.
Right.
So where does the constituent come in
right.
to the dialogue with their elected? So is that possible with Congress?
Yeah, I mean, FASO has essentially said there are a multitude of ways to contact me. He's essentially said, this is just for optics, it's for sound bites, and I'm not going to be a part of it. That's essentially what he said. And he said, I've had small meetings with people, they're far more productive, that town hall meeting is not productive. And there is indeed nothing in there's no congressional rule book that says you have to meet. It's a good idea, right? It's a good idea, and in fact, I saw an editorial from Steve Israel, who's a representative down in Long Island. He was talking about what it was like to be a Democrat and have to go to these town hall meetings that were engineered by Tea Party people to disrupt. And he said, you got to suck it up. You got to go and you got to do it. And that's part of your job, right? So there's no, but I think this gets to the heart of your question as well, which is, I don't think in this instance, this is just my view of politics, I don't think in this instance, you shouldn't conflate law and morality, right? So we want to make the moral arguments, right? We want to make the moral arguments that, okay, you may not be violating the law, right, in not having these town hall meetings, but you're violating our moral democratic principles as they are reflected in the Constitution of the United States. It's democracy that animates the Constitution, right? And part of democracy is you speaking to us, right?
Could you ask PASO to host a series of meetings throughout the district? Could you petition? Could you make it?
Absolutely.
Could you make suggestions about having to do a quarterly meeting rotating around the district?
Absolutely. Absolutely. Will he do it?
No.
No.
But I mean, it's something to focus some energy on. I mean, you gotta find the yeah.
Phone call?
Phone call.
And regular snail mail.
Yes.
But sometimes you're doing that and it's not, it's you making the call, you don't know if they're gonna get it. It's not, I mean, phone calls are important, but building the constituency to try to.
Well, I think it's important another way too, because it builds a sense of community. And there's a benefit from you all getting together, knowing one another, interacting, planning, strategizing. There are, you develop a sense of efficacy, a sense that you can influence politics and shape politics. And even if he's not going to answer you, it's fodder for the next candidate to say, you were contacted X amount of times by several different groups and you refused to show up. That's not democracy, right? You may not have violated the law, but yeah.
So you haven't contacted him, you and Rennie?
No, we were talking. It was actually Rennie's idea.
So I did. 3 weeks ago.
You need to talk louder.
I contacted FASO 3 weeks ago. I made sure his office understood that I'm a legislator. They wrote back right away, one of those form letters where we will, thank you for your request, we will look into it and get back to you.
Right.
So a week went by, and I wrote back and said, hey, you said you'd get back to me.
Yeah.
Where are you?
That's
I've done
right.
that twice now.
Yep.
So next time I send it back, I'll probably start seeing the papers. Because
Yep.
it doesn't make sense
Yep.
for them not to respond to an elected official who is talking with all of her constituents about these issues. I mean, that's my job, right?
Right.
So I would love for you guys to come with me, and for anyone who wants to, we'd have to figure out the size. But if he doesn't respond to that, we have to bring him to the table.
Right.
Before we get into Q&A, because I want to just try to organize it a little bit so we can all hear. Can you summarize what Randy was saying and get to the 9th, 10th, and 14th amendment?
Yeah.
Let's summarize it. And one of the things I just want to throw in, and this is so great, be thinking about all of these things. These are my rough notes that I was just, and spelling errors. Can you talk a little bit about this? And I was thinking how we can bring this back to us in New York State, looking at the Trump dog, not to rush us, but I think if we can start to frame it around some of the things that we've identified in Trump's initiatives, which if you're online, you can find the link at kingstoncitizens.org at the top of the page. And you can see in the index here, we've sort of outlined some of, or all of the initiatives in a way, tried to group them. That would, I think, be helpful as we're getting into questions and answers. So could you go back to finishing through your thoughts on 9th, 10th, and 14th?
Sure. So one last thing I want to say about the judiciary is, let's not worry about this Supreme Court appointment, but the next one I think we have to make a big deal about, because it's really a lot of rights, including rights involving substantive due process, like abortion rights, pro-choice rights, the right to die is another one that will be, I think, important. Gay marriage, right? the equal protection clause as well will be something. So it's not so much this one, but the next one is right. In terms of the remainder here, I want to focus in on the 10th Amendment. The 10th Amendment is one of the principal areas in the Constitution where we see the principles of federalism, right? And in the 10th Amendment, it basically says that powers not delegated to the national government go to the state. The state has something called police powers. It's called the police powers doctrine. And it sounds like I'm talking about the police department. It's a strange phrase, but I'm not. It's a judicially elaborated doctrine. And the phrase police powers is not found in the United States Constitution. But what it essentially says is that states have a plenary power, which is a legal term for saying a broad general power to regulate in the health and the welfare of citizens of its state, right? Public safety, in essence. And some famous cases involving police powers. The Massachusetts case comes to mind where they were able to say to a citizen who didn't want to get a vaccination, you have to, as part of the public good, right?
Zoning also comes under police powers. Zoning
comes under the police powers, which you and Berkey would probably have far more expertise than me. So this is important. Like everything else in the Constitution, you can interpret the 10th Amendment narrowly, or you can interpret it broadly. Conservatives have done a very good job in interpreting the 10th broadly to their ends, right? There's been a new movement afoot. I mentioned it at the very beginning, a kind of progressive federalism. So you can look at marijuana laws in states like Colorado, which incidentally the federal government is starting to crack down on, right? So states like Colorado, California, they're in for it, right? Massachusetts to a certain extent too. This enables, a famous Supreme Court judge, I think it's Holmes, calls states laboratories of democracy. And the idea is that states are closer to the people, they understand geographic differences far better, and that they are better at experimenting democratically. It was states, for example, who pushed for same-sex marriage. It wasn't the national government. It was really kind of a state movement. Marijuana, the right to die, these are all kinds of progressive federalism issues. And there's a great deal of power at the state level. Right? The idea is that the federal government is one of the limited powers. If an explicit power is not given to them, they can't act, but states can. Right? So that means in terms of health care, it seems to me that we in New York State should be pushing for universal health care. Forget about the federal government. Now, does that fulfill our national obligations? No, right? There are citizens in Mississippi who deserve universal health care as well. But we can't do that right now, but we can press for it in New York State. And a whole host of others, we can press for no gerrymandering in New York State, right? So there are a whole host of things that on the state level we can do and we can do well, right? Just like California has pushed for car emissions laws, they're on the cutting edge in many respects of environmental laws. And because they're the largest state, I think they have the 5th largest economy in the world, right? They have an impact on the national government as well. If the national government doesn't want to act, and they do, car manufacturers say, well, I want to sell in California, and it's too expensive to sell some cars in California, not elsewhere, right? So as a de facto matter, they set law. So we have the power under the 10th to do those things. Now, I'm kind of setting up a straw man argument here because there are loopholes. There are varying interpretations of things like the necessary and proper clause, really broad interpretations of something like the Commerce Clause that seek to take limited national power and through a broad definition of commerce, for example, transmute it into a national version of state police powers. So there are ways in which the national government can respond, and we have to be careful. But we've got some leeway to get around here. Yeah?
My question is, how does this apply? What powers are reserved to counties, townships, villages, and cities?
Yeah. There's this
still in rural. It goes the the states have all the power and they can delegate the power through home rule delegation.
Can we rephrase, could you say that again?
Yeah, in other words, okay, that's great, but states have this broad police power, but what about counties and cities within states? And Joanne, who studies this stuff, basically said there's this principle called Dillon's principle, Rick could probably speak to it as well. And essentially, it allows the states to structure the power with what counties can and cannot do. In particular with cities, the states essentially said you have home rule, you're too big, we don't want to get messed up and having to regulate you, so you have home rule. New York City has home rule, which is why New York City can do things that in the rest of the state we're not doing, right, without violating our state constitution or state law.
I'm sorry, you said Dillon's?
D-I-L-L-O-N.
Not for long.
I'll be far more interested.
Just on that.
DY.
Oh,
Rebecca, when you get a chance.
Yeah.
can I just ask one quick question before the break? What about this pushing Betsy DeVos to somehow relent on the Title IX and transgender use? Where would that fall in terms of their powers? We're talking about the Title IX is supposed to protect gender access,
Right.
and gender identity in the schools.
Right.
And so no matter what law we want to make in, for example, the county to protect transgender people,
Right.
we have, the schools already supposedly already had that. So what's going on there?
That's a really complicated question, right? Because, I describe federalism as if there's been one theory of federalism and it's been unproblematic, and they're not. We have this, again, abstract principle of federalism, but there have been different theories about how to make it operative. And in terms of education, it's largely been a matter left up to states. Historically speaking, states control educational policies, right? That's begun to change, right? The federal government has tremendous amount of money to spend. And so you can decide not to follow the Common Core, but then you're not going to get federal money, which is effectively saying, it's effectively you have to,
Or
right?
ADA, for example. Right.
Right. So, they have the power of all this largesse to bully, in essence, more progressive communities who don't agree with their standards about education. So I think what can happen is that local school districts can say, this is our interpretation of the Title IX issue, or the transgender bathrooms, or unisex bathrooms, however we conceive of it, and whatever policy solution we want to put forward. And we have the rights to do that, right? We have the power to do that. Now, what can happen is we can be denied federal money, right? That could be a consequence of it. It could be a consequence where effectively they don't care. You can set your own kind of community standards and they're actually not going to enforce this federal policy. But I think where they get us is the federal money, right? Under standards of federalism, right, we are allowed these broad powers to do as we please. Right? As long as we're not violating the Constitution. For example, Sanctuary City, one of the issues was brought up, well, how can we put in place Sanctuary City policies without violating the Supremacy Clause? We weren't violating the Supremacy Clause. We were saying, that's your realm, and in your realm, you enforce it. In our realm over here, under federalism, we exist in a different realm. We're going to do our thing, and we're not going to help you. Right? Which there have been several cases, I think the Brady handgun law that the court struck down supports that view, right?
Can we move on to the 14th Amendment?
Yeah.
Actually, if you could write your questions down, because I really, really think, and I'm sorry I didn't say that, but what I want to do is bring us, it's 2:30, so I want to bring us around. So maybe we can get to more of that.
Well, Jen, too, that issue, the transgender issue, Title IX, also raises questions under the 14th Amendment, right? Under equal protection of the laws, it raises questions potentially under substantive due process. Yeah, which that's a whole other complicated issue. We know in the same-sex marriage cases, those two clauses have been entwined in important ways, and we could foresee those clauses being entwined in the Title IX case involving transgender bathrooms. So we got other potential obstacles for an administration to overcome.
Right.
I mean, I think in terms of policing, in terms of racial discrimination, in terms of discrimination against gays and lesbians, transgender, prisons, right?
Would they want to privatize the prisons? That's all I wanted to get in, that's all.
They have it.
And I just wanted to know if, can they do that, you know? Trump, a corporation wants to privatize the prisons right now.
So the question is about privatizing prisons. And again, what I'd like to try to do now is wrap up where we are. Obviously, this is so complex. Take a minute break, come back and look at the Trump document and start applying some of this to what we're looking at, what he's saying he's going to do. And I want to share with you some of the contexts that we've mapped out that we can actually expand upon, that Lynn is in fact partially responsible for in giving us the context of some of these initiatives.
Yeah, my cliff notes is he's got to operate in a political context, and it's not just all fun and games. He's going to face real obstacles. There are real architectural hurdles that were put in place, designed by the framers, that he's got to overcome. And in terms of the judiciary in particular, the judiciary in the past, let's say 20 to 30 years, has been very important in checking the power of the presidency. So it's not all bad news. It's not all bad news. If you understand the Constitution, right? Congress, I think, has the lowest approval rate since we've been checking these things, right? I think in part, some of that's deserved, don't get me wrong, but in part, it's also ignorance on the part of the American public, because Congress was designed not to do stuff, right? It was designed to maintain the status quo. And so if you understand that, it's also a very porous system, lawmaking in the United States. If you understand where the levers are, as I said before, you can create changes. So we've got federalism, we've got a great deal of power here to influence state government and to make real progressive changes and to put New York State on the map in terms of being progressive. And we've got a political context, a constitutional context, and where we've got some stuff on our side. We've got some power. That's the Cliff Notes version. And my students are like, oh, great. But that's it.
So and what we can do in the context of your question. And that's what Lynn and I were just discussing. So if you could ask a question, let's keep it brief. Lynn will do a 2 or 3 minute response so we can get as many questions in as possible. And even before that, what I'm hearing too, from a few of you, is what can we do to take weekly actions, et cetera, et cetera. And I've been collecting some of the groups that are organized to do different things within the context of the times that we're in. And this, by the way, is part of the Trump doc that we have. So it's right on the second page, where I'm putting together whatever I can to help the public to connect with what's happening. So if you have anything that you'd like to add to that and to this document, and we'll get into this more throughout the year, and certainly in between our panels if you have questions, you can send it in your information. I can post it. You can make comments, which we can discuss at another time, because I want to really take advantage of Lynn and your questions. But I just want to point this out, that we're trying to grab as much as we can. We want you to connect with the people who are already doing specific things that are in line with what you want to do. That's really hard to do. There's no place right now where it's all combined somewhere so we can see and plug in, right? We don't have to reinvent the wheel, right? So the other thing I want to say that I didn't say at the top of this meeting is that whatever point of view Kingston citizens has, or that you have on the current administration, that the goal here, one of the things that I've been thinking a lot about is, why didn't we do this sooner? That, Trump has definitely inspired us to think about how these connections are all made and what the checks and balances are. I know my heart is in local government and community, but I'm finding this so helpful to start to really think about how it's all connected. how important it is that we see one another and have these discussions off of Facebook, off of social media, because the more conversations I have with those who do have opposing views, we have so much more in common than, and I think you all probably find that too. 90% of the time, we have the same understanding, it's just a different interpretation, and also sometimes a different way of approaching the same very fundamental thing. So over the course of the year, and even now, I don't know, maybe there are opposing views here. I welcome them. We welcome them. Let's have them, let's hear them, and let's learn from one another. And that's what's really important this year as well. So I want to say that just in case there's anyone in here who might be here, who has a different point of view on Donald Trump or on any issue, and I want to welcome you to please speak as well, because I don't know everyone here, and I just want you to be comfortable. So with that said,
We won't shout lock, hammer,
right. So with that said, we'll just start taking questions. Could you stand too so that we can hear you?
Let's all speak up loud.
Okay,
I'll try.
Microphone.
We do need a microphone.
Yeah.
Next time have a microphone.
Okay. Up until about 2 weeks ago, I was operating under the erroneous assumption that all judges needed to be lawyers. And I came to find out that's not actually true. And I wondered if you could say what is in the Constitution about the appointment and confirmation of judges and what we may need to be on the lookout for in terms of appointments of judges.
Yeah. I mean, there's nothing in the Constitution that says that in order to be a judge, you must be a lawyer. There's very little discussion about qualifications to be a federal judge. So you're right. Theoretically, you could not have a law degree and be a judge. Although I don't. At the local level, there are some justices of peace. There are some other local judge positions where you don't necessarily have to be a lawyer. So there's not a lot there. Now, by tradition and practice, appointments to the federal courts are lawyers, and they are political appointees. And, it's hard because when you look at judicial appointments to the court, they're supposed to be based on their qualifications and based on their ability to interpret the Constitution. But inevitably, partisanship plays a role because, again, I was saying the Constitution is this document of abstract principles. It needs to be interpreted. And whenever you talk about a text and you talk about language, there's ambiguity. There's got to be some values or theories or philosophies operating in the background as context to help bring meaning to what are otherwise kind of ambiguous parts of the Constitution. So what you want to look out for, is the long and the short of it, is their method of constitutional interpretation. Right? If someone's going to tell you, I strictly interpret the Constitution, one that is intellectually incoherent, it's not possible to strictly interpret the method. That's a sign that you're talking about a judge who is not progressive and is not going to support things like a right to privacy. Right to privacy, that phrase is found nowhere in the Constitution. It's part of substantive due process in the 14th Amendment. You can find it in other places too. Sometimes justices will textually anchor the right to privacy in the knife. The right to privacy enables us to make some of the most profound and intimate decisions we'll make in life. Who to love, whether to have children, whether to use birth control, how to die if you're terminally ill and suffering. So, and again, Madison says something because it's not there doesn't mean it shouldn't be protected or that it's not fundamental. So somebody who says something like that, it should raise a red flag. There is no way to strictly interpret the Constitution, period. People who invoke originalism, that's a terribly problematic way to approach constitutional interpretation, and I'll tell you why. Because, and I think Gorsuch, is a guy who believes in originalism, if I'm not mistaken. And the idea is that if there's ambiguity in the text of the Constitution about any principle, you go back and you look at what the framers of the amendment intended, right? So the 14th, don't forget, 14th Amendment, there were different framers in the original Constitution. So the idea is if you're uncertain about something going on with free speech, due process, whatever it is, you go back to the framers and you interpret. All sorts of problems with that, right? Because it makes it seem like they have an anxiety about justices interpreting the Constitution and it being anti-democratic. Non-unelected lifetime tenure justices, and they're reading their own views into the Constitution. But the fact of the matter is, right? The Constitution is a document created by many people, not just one group that thought monolithically. There were lots of different views. They were controversial. They fought with one another. They often buried those controversies with ambiguity, right, in the Constitution itself. If you go back to the Constitutional Convention in Philadelphia, they shut all the windows. I grew up in Philadelphia, tremendously hot, humid. They shut the windows. They closed the shutters, no note-taking, right? So what do you do in that instance if the intent of the framers was to not let you know what their intent was, but instead to look at these principles in your own time, grapple with their meaning and apply it? What do you do then, right? So there's some people who say, I'm an originalist, and my originalism says we got to grapple with what equality means in 2017, not 1789, right? So I can go on and on about. But also, when you decide, I'm going to look at what the framers said about the First Amendment. Which framer, right? That's a subjective choice. And they're making the case that, it's just, I'm not reading my views. When you make that choice about which framer to use to interpret what the Establishment Clause means, that is it's not reading your own views in the Constitution. I wouldn't say that they're not your personal views, but you're making a subjective, interpretive argument. It's not value-free, and you shouldn't hide behind it, right? So I think those phrases, to me, raise red flags immediately.
But what is to keep Trump from appointing, say, a Steve Bannon or Stephen Miller or just some random person with extreme views to be a federal judge? Or
he could, but by tradition and practice, I don't think
the advising consent of the Senate Judiciary might stop that.
Yeah, that's right. Hopefully they would stand up and say no.
Yeah.
You're right.
Enough
Yeah.
lawyers in the Senate to say no.
No.
Explain there's the opposing doctrine of the living Constitution.
Okay, right. So the alternative understanding of the Constitution.
Say the question.
Oh, he said explain the alternative version. I basically said you hear strict constructionism. I strictly interpret the Constitution. Originalism, that raises a red flag. The alternative understanding is that the Constitution is a living document. That there are these broad concepts in the Constitution, for example, equal protection of the laws. Well, that doesn't say anything about I should say there are these broad concepts in the Constitution. It doesn't say anything about the particular conceptions that we use to apply those concepts to cases, right? So the idea is if you look at equal protection of the laws, right, that we're talking about equality. But there are different theories, different particular conceptions of equality. One would be colorblindness, and that is sameness of treatment. It's never okay for law, for example, to make any distinctions on the basis of race. Doesn't matter if you're making a distinction on the basis of race to help a historically oppressed group or to hurt them, right? It's never okay. Another interpretation of equality, the Equal Protection Clause, would be the anti-caste interpretation, which is to say that the job of the Equal Protection Clause is to eliminate caste, racial hierarchy. And if that means we have to make distinctions in law on the basis of race, provided that those distinctions are made to eliminate racial hierarchy, it's perfectly constitutional. But here again, we can all agree, segregationists can agree. We're Americans, we believe in equality. Where the rubber meets the road, I think is the expression, is in the particular conceptions, the particular theories that make that general abstract principle work, and there we're going to disagree, right? I mean, you immediately think of affirmative action. If you're against it, you probably have a colorblind interpretation of equal protection. If you favor it, you probably have an anti-caste interpretation of equal protection. So, and the idea is, again, that these concepts, they have to be interpreted in our times. The Constitution's going to endure if it's going to be something other than just a parchment, a piece of paper drying out in the Smithsonian. It's got to be because we read the text of the Constitution, we grapple with it, we debate about the meaning of these concepts, and we make them apply in our own time. Right?
Okay?
Yeah.
I have a question. You were talking about gerrymandering, and what I hear a lot when I'm at rallies and when I'm talking to other activists is we're gonna make it come out in the midterms, or we're gonna sort of equalize this or have better action. But in terms of the role that gerrymandering plays, and it's possibly, I mean, when you looked at that map in the election, you could see how important it was and how it affected the Electoral College and the ultimate outcome. And maybe it's less of a concern in New York State, but I feel like it's also a concern because then people feel like their vote doesn't count because New York State is kind of something you can count on to go a certain way. If you lean that way, maybe you don't even go out to vote. So as a constituent, how do we address the issues and the reforms that need to be made, or how does gerrymandering even sort of happen, and what's the ask? Like, who do we ask, and what is the ask? How do we affect the change that we want to see where our vote is not erased?
Right. So somebody asked kind of a similar question at the break, and you were less, and I'll let you explain why later. But so gerrymandering, well, redistricting occurs every 10 years. The Constitution requires it. It's why we take a census. And essentially, the operating principle in the United States in terms of setting criteria for fair representation in the House of Representatives is one person, one vote. Right? So we have to take a census to figure out if people are leaving the state, in which case we've got to redraw districts and we'll lose a member of Congress. I think the last time around we lost 3, if I'm not mistaken, because we're in the Rust Belt, we're losing population. The Sun Belt is gaining population, right? If you gain population, you draw districts, you draw more districts, right? All around the idea that it's one person, one vote. And there's we could get into so many problems with the way the census is taken and whether it really is accurately counting people or not. But setting that aside, some, for example, want to say we should take a representative sample. That will better tell us about population. Others say, no, you got to do it the old-fashioned way. You got to knock on doors, and if people don't answer it, you got to keep trying, kind of thing. So it happens every 10 years. We tend to keep losing districts, and then once it's time to redistrict, it goes to the state legislature. Whoever controls the state legislature, Republicans or Democrats, controls the redrawing of those lines. And so, typically what happens if Republicans are in, or Democrats, whomever, they're going to draw lines that benefit their party. Now, I've never really understood the term gerrymandering, because it seems like it's gerrymandering, all of it's gerrymandering, right? You're trying to redraw district lines in a way that benefit your party. So one way to do that is to concentrate Democrats, and say if Republicans are redistricting, all in one district. And then to spread out the Republicans so that they number just a little bit more than the Democrats in the surrounding district. And this gentleman over here gave me a great example. He said, I think you said Democrats won most of the votes in one part of the country.
Oh.
Yeah, go ahead.
Democrats have had a plurality of votes for the House of Representatives for a long time, and the Republicans have taken the House because, we'll use Ulster County as an example, you can draw, many states, Democrats would get 52% of the votes statewide, and Republicans would take 2/3 of the seats. And the reason that this is possible is that you take a district where you put 98% Democrats in, and then you take a district where you have 55% Republicans, 45% Democrats. And on the one hand, this is bad news. On the other hand, it's good news. Because it means that in a district such as where we live, you can swing the election just by getting your voters out. You don't have to convince a single facile voter to change. You simply have to make sure the people who didn't vote the next time, and you swing the district. So on the one hand, setting up these close districts that are just slightly favor of the Republicans gave them a huge edge. On the other hand, it gives them a huge risk.
You can see it that way, right? I think the thing is, too, that we have to be careful about redistricting next time, and we've got to be on top of it.
And we have to pay attention to who we put up in Albany.
Yes.
That's the key.
Yeah. Yeah, but it's rooted in the Constitution every 10 years. Berkey, did you want to?
Also, the Constitutional Convention is up for a vote. Is it this fall or next year?
The state one, yeah.
Yeah, so I think that's another issue to push on, is whether or not we even get to have a constitutional convention in New York State.
Yeah.
Because it will allow us to bring to the bring to the table the idea of having a better system. In fact, in Ulster County, we did the redistricting in my office, and League of Women Voters oversaw the process, and it was very good, and it was considered a model. And if we could talk about, in the Constitutional Convention, having a model like that apply at the state level, something that doesn't privilege one or the other party.
And doesn't polarize.
Sorry, and who are you asking to have a constitutional convention?
Sorry, how do you ask for that?
Like, who are you asking?
Well, there are many, many delegates to the Constitutional Convention. I think it's actually quite open, but I think that's for another day. I just wanted to say that I think that's something, for example, in the coming months and so forth, we'll be talking about relevant issues on Kingston citizens, and that's a critical one. It's one of the reasons why we're talking about the charter later this year, because we want to talk about the idea of actually rebuilding our own Constitution. That's very important. An asset of good governance.
Yeah, and I think that I pulled up, and again, the Trump document that we've created, we've done a lot of work to outline some context of New York State and local efforts work. And Lynn had mentioned earlier that, and this is a statewide thing, but that Cuomo has created this independent redistricting commission, and learning more about that going from individuals to computer generated modeling. So, which I don't know what the pros and cons are with that, but this is what's happening. It's in this document, some of this that can help, and as you're researching, to share, so we can continue. The whole idea is to keep finding out what's going on, what we can do. So this is the New York State.
I just say generally as a political scientist, people believe wrongly, I think, and this comes from someone like John Rawls, that process is neutral. No, it is not. Don't you believe that for 1 second. Process predetermines certain kinds of outcomes, makes certain kind of outcomes more likely. So if you go this direction, you go to a constitutional convention on the floor open, you got to make sure that the people are there who are going to support it and structure it properly in such a way that you're going to get the outcomes that you want. Now, the outcomes you want are for fairness, less polarization, right? Less concentration. Those seem like ethically defensible principles to me. But it's, the notion that, these computer models are going to produce something different, right? And you've got to be on top of it. You've got to be on top of the process. You can't just let it go.
And by knowing it, we're taking steps in that direction.
Yeah.
Because if we don't know it, then we're not aware, we're not involved. So these are some of the things that are in the Trump document. Another question?
I just wonder, can we talk a little bit more about ballot initiatives and what exactly we can do with ballot initiatives and how we do them? I need to be educated a little bit about that. It seems like a lot of early change comes from them.
Yeah, so those initiatives come out of the progressive era, and they're meant to allow people to have more of a direct effect on policy outcomes. So referendums are, I always get this confused. Referendums come from the state legislature, and they allow the people to vote yes or no. What's the one that initiatives start with the people, right? Bypass the legislature and directly put forth a policy the people direct on, and recall, right? That's where prior to an elected official's end of the term, you can pull them out of office if you think they're doing something terribly wrong and problematic. You don't let them stay until the end of the term. States have, Jim, did you want to add to that?
Well, I don't think that New York State has initiative.
California.
California does. California has had it for many, many decades, and that's why some of the progressive events have happened out there, because it's not controlled. Whatever. But they're citizen-oriented, they're citizen initiatives, which we don't have in New York State.
Yeah, I mean, you have to be careful with citizen initiatives because they can run amok. California's got a terrible, I'm sorry.
Prop 13.
Yeah.
Yeah.
California.
Yes.
I mean, their educational system, the cap on property taxes. So you gotta be, I think you gotta be careful and responsible with referendums. But we have them at the local level.
No, we have the state level.
We
It
have-
does not exist at the state level.
But at the local level, we
You can
do.
do whatever you
I
want.
think county and, right, but the county had a referendum at the county level and the.
We've just had a couple,
Yeah.
last election.
I'm sorry, I'm Googling something.
Right. Yeah.
Yes,
Back
we
to
do.
the U.S. Constitution for a minute. Can you talk about the resistance strategies of impeachment and changing the Electoral College? How that works and whether there's anything to do there as a practical matter?
Yeah, I mean, I was thinking about this with your question too. There's nothing in the Constitution that says that the states must take all of their electoral college votes and give them to winner take all, right? In other words, we have most states just by history and tradition have winner take all. So you could win 51% of the votes, but yet you take all of the electoral college votes that go to you, and that puts you over the top. Right, so that's one way that at the state level you can change winner take all, presidential election, winner take all the electoral college
Two
votes.
states that allow this.
So, yeah.
Maine and I want to say Michigan State.
Michigan? Or Wisconsin?
Nebraska or
Nebraska.
I think it's
Nebraska.
Nebraska sounds right to me. So that'd be one change that we could quickly make without going the electoral college route. You know, the electoral college, you're going to have massive state resistance, right? Because one of the ways in which the United, and I don't think I really talked about this, but you know, the framers, the Constitution was not a democratic document. It was not intended, you know, there's like this core paradox at the heart of the Constitution, which is to say all legitimate government requires ordinary people to consent to it, but you're not okay to govern, right? Like we need to keep you at a distance between representatives and governing. So the Electoral College is one way to do that, indirect election centers, etc. The Electoral College is, you know, there are big debates now. It's a remnant, some would say, of slavery. But in essence, it's undemocratic, right? Because it weights the vote in such a way, just like the Senate is potentially undemocratic. Idaho, which has like no population, California get the same number of senators. How is that consistent with one person, one vote, as I was talking about earlier in terms of gerrymandering principles, right? It's not. So, in the Electoral College, basically the number of Electoral College votes that each state gets depends upon their congressional party, their congressional numbers, the number of representatives they have, which are based on population, plus 2 senators. Every state gets so it's weighted in favor of less populous states. So you're going to have a bear of a time, right, trying to get those less popular states to concede political power.
How many do we need?
Oh my gosh, well there are two different routes to propose and 2 different routes to ratify. You need a constitutional amendment. And so you're talking about an extraordinarily difficult process, right? The Constitution speaks to 2 different ways to do it. You can hold a convention, which was done once and never again for obvious reasons. And then you have to have a certain amount of state legislatures ratify and propose laws to come
And
out.
one of the issues is right now we have too many state legislatures and governorship that are Republican.
Right.
So we're within that tipping point, so we don't want to go that route.
It seems to me the lower hanging fruit is to go after winner take all.
Right.
That you can attack that at the state level, and that would have helped Hillary Clinton. I mean, a lot of those races were very, very tight. Pennsylvania, Wisconsin. I mean, we're talking about, you know, very small percentages. I think 2% of the vote in some instances. So that's the lower hanging fruit.
What do you think about impeachment?
Here again, what's an impeachable offense? You know, you're going to have
High crimes and misdemeanors.
Right. What are they? You know, it's like treason. What's treason?
There's no background in the Federalist Papers anywhere else. Is what that means.
Yeah, you can go to the Federalist Papers. I mean, the Federalist Papers are still relevant to us because they.
Yeah, I'd also look at the anti-federalist papers. They actually were written to persuade New York to go one way or the other.
Yeah.
Is there a process to prove conflict of interest?
There are federal statutes on the books. Constitutionally speaking, it's not clear that the President of the United States, outside of the emoluments clause, can have a conflict of interest. Strictly speaking, I mean, here again, this is where we want to be careful. Right? Tocqueville said that in the United States, everything comes down to a question of law. Right? It doesn't have to come down to a question of law. Maybe there is no ability in the Constitution to get at the President of the United States because of a conflict of interest. It doesn't mean that morally we can't argue that his business connections aren't really in a blind trust and that they don't violate democratic principles. Right? So we don't have to, well, I guess the argument is we don't have to take law, which has narrow confines. Right? The issue might be more morally weighty than a law and legal language and concepts allow us to get at. And we don't have to be constrained by it. We can make a moral argument, just as we made about abolition or many, many other issues, and put pressure on Congress to say this is not right. So it's great when you have law, right? And we can argue about interpretation, right? But I don't think we should be confined by that alone. Yeah.
I'm suspicious of talk of impeachment, because the problem is if we impeach Trump, then who becomes the president? Mike Pence. If we get Mike Pence out, who becomes the president? Paul Ryan.
Right.
So I think the real problem is when you look at the numbers of Democrats at state levels who've been completely obliterated. We've lost 1,000 Democratic state legislators over the last 8 years. And that's where we need to focus, I think. So that, and I think that's also what we can actually affect. We can't do a whole lot to, make that impeachment thing happen. Not here, at this level.
I will say this, I do think the story about Russian intelligence involvement in the election, it's got traction and it's not going away.
Sure.
And I think that would cause, to me, that's the issue more than the conflict of interest issue that might trigger an impeachment depending on what we find out. I mean, I'm reminded about the amount of time it took for Nixon's malfeasance to become public. And it seems to me that Trump keeps saying, this is fake news, and he's poking the eye of the intelligence agencies. And sooner or later, I think we're going to get transfers, and we're going to be outraged. And then if that happens, that's a lot of ifs, right? But if that happens, then we got a constitutional crisis. Because some people are going to claim that we're politicizing impeachment. It's also, here's my concern too, which I hope is above partisanship in this instance, which is, Flynn had to resign over leaked intelligence reports. I mean, that's a lot like Hillary Clinton and the email server issue. Neither got due process rights. Right? Neither got a day in court. We didn't get to see the transcripts. It was really rumor. And this is really a misuse of the intelligence agencies in a way that may come back to bite all of us, right? Including Democrats, right? Like right now, I can't help but be a little bit gleeful that this stuff is coming out, and I'm thinking, right, more is going to come and you're going to get it. But the problem is that is not, you're innocent until proven guilty. And I by no means want Michael Flynn in office, don't get me wrong. But we got a problem with the rule of law, right? And we can't, people refer to the intelligence agencies as the deep state. And you don't piss off the deep state because they come back to get you. And you heard Schumer say in a very prescient way, I think he said 20 ways until whatever, right, to come get you. And I think all of us as Americans should be concerned about that. There's an ongoing investigation, and I don't think it's going away. And I think we should let them do their jobs, and if they find something, then we got to go through due process. So,
but I think
there's traction.
Resignation, Lynn, was the way they thought that would cut off that route.
Yeah. Oh, I know. I don't think it is. Yeah, no. There's ongoing investigations that we don't know anything about.
And if Trump is impeached, then what happens to Bannon? Like, how do we impeach Bannon? He's the one I really want to get out of it.
Yeah, he would likely, under a new president, I don't. From what I understand, Pence and Bannon don't really get along, so he'd likely have to step down. But he serves at the president's will, at the president's pleasure. And you're right. I mean, Pence is a real. I'm really torn because if Pence gets elected, say that we go the impeachment route and Pence is in office. On the one hand, Pence isn't going to undermine democratic norms in the way that Trump has. Like, I'm really terrified about that, right? But on the other hand, he's going to be way more effective, you know, and he's going to be, you know, in terms of policy, progressives are going to be nailed in ways that, you know, through incompetence and a whole host of other things, you're not going to get nailed now. So I'm really torn. But I think, you know, the tweets, the attacks on the press, and private citizens. You know, I read a newspaper article over the summer where this young girl stood up at a campaign rally, challenged him, and he tweeted, you know, disparaging her, and then the alt-right was unleashed on her. She's a private citizen. She was a 17-year-old poet. She got threats of rape, threats to kill her family. That's silencing, right? And democracy is dialogical. It cannot function if people feel threatened, scared, and silenced, right? So to me, I'm really torn and really terrified about that. I mean, as professors, there's a professor watch list, and some of these like world-renowned professors were put up there because they were liberal, and you know they're undermining constitutional principles. And the AAUW said, "All right, you're going to put them on, put all of us on." Everybody wrote in and signed their names and said, "Put all of us up there." But that's the kind of silencing effect, and it really requires ordinary people. And I see it at the local level all the time. There are these local citizen blogs that go after people, particularly women, frankly. And they go after them and they attack them. They attack them in terms of the way they look. They attack them in terms of sexual violence, right? And that's not an attack on one person. That's an attack on democracy. And, you know, I think in situations like that, when you see that happen, we all need to stand up and say, stop it. That's not democratic. It's uncivil. You're not allowed to do that. Yeah.
Yeah, pertaining to that, I'm a survivor of domestic violence, and my perpetrator had destroyed my house to the tune of $30,000, and the only thing I could finally get him arrested for was that he cursed at me and threatened me over the phone. So what I'm wondering is there a class action, a citizen suit that can be brought against Trump? We've got ample recordings of him insulting myriads of people who would represent us, for instance, women.
Yeah.
And I don't know what, but you know, I just keep thinking I want to start a class action suit against him for harassment, and it's a, you know, if my ex-boyfriend was arrested for that, why is he immune?
Right.
He's been threatening everybody all over the world.
Yeah. I mean, there is a group libel case still on the books. It's not considered to be good law anymore, constitutional law. It's never been overturned. So that you could argue that what Trump is doing is engaging in group libel.
Is engaging in what?
Group libel. It's pretty much hasn't been used. And the other big issue you have, you know, as a lawyer, you have to have standing, right? And there has to be a remedy. So those would be larger issues. But again, there are also moral issues that we should all be talking about, and we can create civic norms. That's a violation of a civic democratic norm that we should all be outraged about.
So how do we organize that? That's what I'm saying. Like if we could do a class action suit or whatever, what did you call it?
A group libel.
A group libel, that would make it cohesive, coherent, and one block.
You know, here's the one problem with law. You know, like law actually is a very blunt instrument to get at justice. So there are real limitations to law, and sometimes if you're seeking justice, there are better ways to go about it. And I think in instances like, because I wholeheartedly agree, the way in which I would want to interpret law, I think it's okay to bring a group libel case, and I would argue that that's not a violation of free speech. You know, people get upset about, you know, regulations on free speech. In the United States, and I'm talking about regulations on hate speech, I'm talking about like regulations on the most vicious and violent and pornography and consent free speech, you can be fired from your job for placing a political sticker on your car and you go to work and your boss doesn't agree with it and you get fired. And it is not a violation of free speech.
But then how come I could get him a misdemeanor based on his threat over the phone?
That's exactly it, it's threat.
Trump
When does
Hillary.
speech become action? When harassment has speech elements, but it's more action. Threat has speech elements, but it's more
But he's
action.
threatened a number of times, hasn't he? I remember when he threatened the Second Amendment, people could show up and you know what to do. That was a threat.
Yeah, I mean, I happen to agree with you. I think the court would say there's got to be an immediacy to the threat. And a likelihood of him carrying it out.
You know what, though, there's something I just want to say. I remember, because I'm one of those people who gets harassed from time to time by anonymous whatever. But there's something, I actually, it's not a piece of paper that's funny. That was Freudian, I love it. So the thing about tort, what I learned about it is that there is a way, and it's difficult with threats not threats, but and certainly maybe George or someone else could speak to it. But there's something that they're working towards with social media, with online language, which is something that encourages violence. Right. Which they're trying to actually, because what's going on with the internet is it's very new, and some people stand behind their First Amendment right to say whatever, to take it as far as they want to take it. But so this was something that was encouraging to me, because it's coming into the discussion on what people are doing and saying online and otherwise. So. Am I describing that correctly?
Yeah.
Good enough. Sure.
Good enough.
When we tried to get the memorializing resolution, I'm sorry, when I was in school, when we tried to pass the memorializing resolution regarding hate speech and acts, which was memorializing, everyone remembers, so we weren't trying to infringe on anyone's rights. I was looking into the First Amendment, and there are ways of curtailing it if you use fighting words or something that is called incitement. And what that is that if you incite violence, right, the Supreme Court has found in this very narrow instance that if it's direct, if it can be drawn, a direct connection can be drawn, then it can be actionable. So for instance, if you burn a cross, okay, no one can stop you. But if then marauding citizens go and damage everyone's property as a result of that, that's the incitement. The other thing is just damaging, let's say, property, or might be, if it's on someone's property, might be considered, vandalism, because it's free speech, right? But if then everyone goes as a direct result of that and starts breaking into people's houses, that's incitement. So it could be, I was thinking about this all week after we lost that battle, if we could look into the incitement that has happened in terms of bomb threats, desecration of cemeteries, or violent acts that have been documented. I'm just wondering if that's just a thought, I don't know.
Well, I'm sitting here thinking there are lots of ways to approach it. First of all, again, like I said, when you look at the First Amendment, you look at free speech, it has to be interpreted, because we do regulate all kinds of speech. And, one way to look at free speech is to say there's high-value speech and low-value speech. Low-value speech is regulated all the time, like sedition, you could argue burning a cross on a family's lawn, although that case went the other way. But, the speech you want to give the highest amount of protection to is political speech, right? And there are things like time, place, and manner restrictions, right? So you might be able to burn a cross at a certain time, at a certain place, in a certain manner, right? And there are other times that you couldn't do it, right? So, there are all different ways to look at the First Amendment and to look at what it allows or it doesn't allow. So I would just say, too, what's problematic in the cases that we're talking about here is we have this old-fashioned view of the relationship between liberty and equality. And we're going to see it, I think, too, in terms of gay rights, right? Your religious liberty to not serve me because I'm gay. And I think I was just reading before I came over here a Michigan doctor refused to treat a newborn of a same-sex couple because she had preyed on it and decided it was wrong, right? So under these new religious liberty laws, she's going to be allowed to do that. That's her religious liberty, her freedom, you know. But it also runs up against the same-sex couples' equal protection rights. And I think we're talking about the same thing too, like in this case, the IIV case, burning a cross on the lawn of the only African-American family in the neighborhood violates their equal protection rights, right? Just as you might say this guy has the liberty to make any kind of political statement, in this case it's symbolic speech in terms of burning a cross that he would like to make. So there's this balance that goes on, and it's often weighted in favor of liberty rather than equality, and I think that's problematic, and I think a lot of it has to do with the precedents that were handed down by an overtly racist Supreme Court. Some of those precedents, it's what's way past time for them to go, right? And that would change the meaning, the reach, the scope of the 14th Amendment, I think, in very positive ways that would change this understanding of speech. You know, is speech action? Right? I think that's the question. When does speech become action? I mean, sometimes we recognize it in very unproblematic ways. If you, oh gosh, I forget the legal term, but if I call you and they say, look, Rebecca, you either give me $25, or let's say $25,000, that'll make it worth it, or I'm going to tell everyone about this secret, right? What is that called? Blackmail, right? That's a very verbal crime. Right, but we don't recognize it as such. Sexual harassment gets into sort of blurry territory, but it seems to me that we don't give enough protection to the highest level of speech, which is political speech. Now let's say one other thing, another troubling element that's going on. I think I saw in the paper about 12 states are beginning to do this. Their state legislatures, which we've got to be careful about in New York, I don't think we have a lot to worry about in New York, but we should be careful, are changing laws to make it more difficult to protest. Yes. 17 states, you're going to get punished. In Arizona in particular, it's a really bad state. Well, actually, because they're applying anti-racketeering laws.
To interject here, I did read that Kinderhook, the town board, is initiating, I'm not sure if it can be a law, but whatever they're doing to keep people from protesting because of all that's been going on with FASO there, because that's his district office. So we should be looking into that. So we're going to take one more question. David.
So if the whole Constitution is dependent on one person, one vote, how do they merge corporations into one person?
Yeah, this is the biggest
question. Yeah, I've got it. Can you repeat the question?
Yeah, basically, you know, if we're talking about the 14th Amendment, if we're talking about one person, one vote, how do corporations figure into this, and why are they considered to be persons, right? And this is the biggest, I would argue, legal sleight of hand, right? If you go back and you try to read the case that establishes that corporations are people and that they deserve all the same rights listed under the 14th Amendment given to individuals, it is a footnote. I would argue it's dicta, right? It's a footnote. There is no explanation, and when that footnote gets reused and reused and reused, and suddenly it becomes a long-standing precedent. And by the way, corporations became people at a time when African Americans were still not covered under the protections of the 14th Amendment.
When was that, do you know?
That was 18.
The corporations became people
Yeah,
in the 1800s.
late 1800s. Yeah. Right, and I forget the name of the case, you know?
Santa Clara, 1870s, 1880s.
Yeah, go look at the case, go look it up, see the footnote. No explanation.
Santa Clara versus a railroad company. Yeah.
And the most recent Supreme Court decision does two things, right? Citizens United does two things. It has two operating premises that have become precedent. The first operating premise is that in the context of elections, money is free speech, and therefore it can't be regulated. And the second operating premise is that corporations are people. You wed those two together, and you have to remember, you know, the United States, the framers were anti-corporate in character. They had bad experiences with corporations, and to be anti-corporate is not to be anti-business. Corporations operate behind the corporate veil.
And so So going back, corporations actually in the 19th century actually served at the pleasure of the states. They also had a drop dead date, and they had to do public good. So they had to do something good for the area, and they also only existed for a certain point of time. Now corporations don't have to do public good or public service, and they don't have they live on forever.
They are granted charters for in perpetuity, right? And literally, this all changed. In the late 1800s, they would literally take sacks of money into state legislatures to get these corporate charters changed in ways that benefited them. And the problem with this, corporations can do potentially great good. They bring together capital of all different types, intellectual capital, resources, and they can leverage it to achieve great goods. I think the great question of our time is how to harness corporate power to the public good. And that was severed.
Didn't we talk about the difference between corporations and business, though?
Yeah.
And you can explain that a little bit too. Because business has more of a face, and they're responsible.
Business does not operate behind the corporate veil, right? So if you do something as a business owner, like dump glowing green sludge into the Hudson River, as a business owner, you can be held publicly accountable. You can be held under criminal law, right? But as a CEO of a corporation, you can knowingly do this and not be held personally accountable, right? Because you operate behind the corporate veil. And corporations are a legal fiction. We create them, and we create them to I think, operate in the public good. Now, I think there are two different ways of looking at corporate power. In the United States, we have a shareholder understanding of corporate power, and under corporate law, they are required to act to the benefit of their shareholders, to make money. Right? In Europe, they operate under a stakeholder conception, in which if there are two different options, one that's going to make your shareholders a ton of money, or one that'll make you less money but is better for the public good, they must operate in the public good. Right? So we have law, right, that directs corporations to behave in ways that are really divorced from what's in the best interest of everyone. It's not to be, not to say that corporations don't perform, very legitimate and innovative functions. They do, and we need them. But this severing, right, and we can see it at a very particular historical moment, from corporate power, from the public good is a terrible problem, and then you bring it together with the notion that money is free speech. Corporations have enormous resources. I mean, Teddy Roosevelt, right, argued, as he saw the rise of corporate power, he said the only entity that's going to challenge that concentration of power and money is the government. And you can kind of see this in the Republican Party. There's an element of the Republican Party that wants to do everything it can to make government wither, right? To make regulatory agencies wither. That's the flip side of Citizens United. It's the flip side of corporations as people.
I just want to bring, as you're speaking, I keep going back to the Trump document that we have, and so much of what you're saying has been fleshed out in here because, citizens have been working on this for several months, and I want to bring you back to this document. I'm sorry, I'm scrolling. So, for example, here's one of the initiatives that we've called regulations. There's a requirement that for every new federal regulations, two existing regulations must be eliminated. This is the format of this doc if you haven't looked at it. So what do we have here? We've talked about what's his motivation, which is all conjecture, but we're looking at it, looking at the context of the initiative, which is really helpful to start to see the larger picture and the other items that actually are a part of or triggered by the initiative. And then we have a lot of what Lynn is saying. In fact, I spoke to her quite a bit about this. But here, then we start looking at New York State initiatives based on Trump's initiatives. and I don't even know if that's the right term now, right? Because we're calling it initiatives, but we'll get into it. Again, this is an exercise for us. So we have New York State initiatives of the things that are happening, the things we can pursue. We have New York State policies and laws, which are very difficult to identify, bringing it down to the county and the city, et cetera, et cetera. So I want to say that some of what Lynn is saying has been captured here, and you can locate it in the document, all of which it's a lot to take in, and that's why we're meeting every month for the year, to continue. And what I want to do before I take Peter's question is ask, and why I'm bringing this up is, so what can we do with this information today that takes us back into our homes, which is a very hard thing to answer. But I'm already getting some great suggestions from citizens, like, because there's so many questions, so much concern and confusion. What's a good step, Lynn, that we can take with our conversation today, either as it applies to our document and trying to capture information, or some other step that maybe we hadn't thought of? And before you answer that, Peter, did you have an update?
Back to your document. There's Citizens United was a federal statute that the Supreme Court decided on. When I think about it, aren't corporations incorporated in a state? Does that then give state? Is there any possibility that we can, as a state, require the corporations act in a way that you talked about shareholders only looking at the bottom line versus shareholders looking at the public good? Right. Is there some way that we in New York State can require corporations? Well, I guess that's the problem, is the corporations go to Maryland or wherever it is.
Yeah, they're moving east. Right.
So if they're incorporated under, well, don't they? Is there any way where they need to get permission to operate in New York State? At that point, is there some place where we have some power to have them act as corporate citizens?
Well, I mean, the interesting case would be California, right? So the argument is that in New York, if we start placing these regulations and make corporations behave in a way that is compatible with the public good, that they'll pick up and go somewhere else. Right. And of course, there are very poor states that want to attract corporate capital and resources, so they'll reduce their, environmental standards and we call this a race to the bottom. Right? So we don't want to get caught up in a race to the bottom. The way to stop that is to have a national standard or a national floor. But the interesting case is California, because California imposes far more regulations on corporations than any other state in the union, and corporations want to stay there, right? So I think there's this new emerging model that says, okay, Republicans in Congress, you are saying all of these things about cutting regulations for business, tax cuts, and let's look at the places where this stuff has been done versus the places where more regulations have been put in place, more progressive tax policies have been put in place. Who's doing better? So Kansas is doing horribly. And they're following the philosophy of supply-side economics, lowering regulations to bring corporations in. California's going in the opposite direction. California's thriving, right? California's saying we want to have a diverse citizenry, we want immigration, we want corporations to have these regulations on, on what they do to the environment, etc. So there's, I think, this interesting.
There's one here that we talked about.
Right, yeah. Right. I mean, by the way, the same conversation goes on at the local level in Kingston in a different way. It comes out in a different way, and I'm sure it goes on at the local level everywhere else. It's like, how do you get business to come here, and what kinds of businesses? It's not businesses undifferentiated. Like, we're not talking about any business, right? Having, the coal industry relocate here is not going to help us, right? So you got to be smart about what you do, and the laws that you put in place, things like quality of life laws, like a bike path, right? May seem stupid and banal, having a transportation system that works, not sticking a gun range right in the middle of an arts district, right? Those are quality of life issues that bring the right kind of businesses to Kingston, that bring sustainable companies to businesses to Kingston, that make them want to stay here. The same thing is going on in California. It's going on in places like Austin, where they're creating a quality of life, and people say, oh, that's a really great quality of life. Let's put our electronics company, let's headquarter it there, right? So I think, that's what California has going for it. There are a lot of corporations who are innovative on the cutting edge, green technology, and those are going to be the technologies and the businesses that are going to make it in the future, that are going to bring us good jobs, right? And so you want to think, what kind of policies do you want to put in place that bring them here? And the policies that bring them here are progressive laws, progressive environmental regulations. They tend to be more progressive in terms of how they want to treat their employees, about immigration, a whole host of other issues. So California, on its face, according to Republican supply-side economics, is doing everything wrong, and yet they are thriving, right? So the narrative on their part in Kansas and in other places has to change. Incidentally, Mike Pence is from Indiana. If you go back and look at what Indiana is doing right now, they're spending an awful lot of time overturning everything he put in place, right? So this is, I think, a larger narrative. Republicans have monopolized the narrative on business and being, promoting business, and it's wrong-headed. They've got an ideology that was best for the 19th century, not for the 21st century. And I think we, as a group, have to press a different narrative and push back. A lot of this has to do with storytelling. And what stories do we tell, and how do we grip people and get them to understand, right? And I'm just sitting here talking about all this legalistic language, and it's hard to follow. But stories are easier to follow. And the story of California is one that we should understand.
Does this relate to, I've heard you say any number of times about morality, moralness in terms of the Constitution, and that even maybe earlier on to talk to FASO, not on a legal level, but on a moral level.
Yeah.
So is that what you're talking about with California doing some of the things? I mean, where in your mind is this morality in the Constitution?
California is not doing anything that violates the United States Constitution. They have broad powers under the 10th Amendment, police powers doctrine. So they're not doing anything that violates the Constitution. And in addition to that, they're trying to say, this is what makes for a thriving social and cultural context in which people who are innovating in the business world are going to want to stay and live and raise families.
So does morality and legalness they're two different things? Obviously they are.
Well, that's a larger philosophical debate. I'm thinking of Hart, someone like HLA Hart would argue that law is separate from morals and that they shouldn't be conflated. And there are others like Ronald Dworkin who say, no, they're absolutely related and they shouldn't be separated. I sometimes think, we get involved in a conversation where we're like, well, where have you violated the law? And, you look at a place like Nazi Germany, right? The Nazis came to power by following the law. So there comes a point in time, particularly in penumbral cases, where law falls short. And then it doesn't matter what law says. What matters is what's the moral or ethical thing to do, right? And also, we shouldn't have to try and fit what is a moral argument into narrow legal language. Right? Sometimes that can be very helpful. Sometimes it's not. There is a larger moral issue. And in the political realm, it's not just about law. It's about our morals as a people, as a democracy. What do we stand for? And we are a liberal democracy. Under a liberal democracy, we're not neutral about certain values and principles. And it's okay to advance those arguments while still being very much part of the democratic tradition, I would say.
So, Lynn, you just opened something that's really important. And that is that we have to pay attention to the laws. The first laws that were passed in Nazi Germany that started the trend against Jews was actually couched as an animal rights law. And it was an anti-kosher butchering law. Okay? The only people that it mattered to were the Orthodox Jews. No one else stood up. The rabbis tried to, and the butchers tried to work around this. They couldn't. The next law was not bringing in meats that had, into Germany that had been butchered this way. But it was couched for everybody else. And this is why framing and reframing is really important. But it was an animal rights act. There was a humane way of killing something that was not the way butchering is done. Okay? And then no one was standing up for the Jews. Okay? And then it became, it's not my problem. And then they realized they could do this against the Jews. And they could do it again, they then passed laws against the disabled and so forth.
I mean, Nazi Germany had a terrible situation after they lost the war and they were trying to rebuild their legal system because people did stuff that was just terribly immoral but was legal. Like they'd inform on somebody because they wrote Hitler's, sucks on a bathroom wall. And that was a violation of the law. You could be caught, sentenced, and put to death. And then after the war, the person who turned the other person in and committed them to death, what do you do with that person? Is it an ex post facto law?
That's actually why, for instance, gay men stayed in concentration camps because homosexuality was illegal. So they were never liberated by the Allies.
I just...
I'm full of fun facts.
Before we get into questions, I want to just acknowledge that it's 5 minutes to 4. And as long as everyone is comfortable with that, Julie, is it okay if we go over a little bit? Okay.
I'm not offended if you get up and leave. Again, I teach 18-year-olds. You have to do a lot to me to leave.
Yeah, I just, I debate this with my girlfriend all the time, but at what point and where is it effective to use civil disobedience? And a lot of stuff I heard here today about when do you not obey a law? And if we read Martin Luther King letters from Birmingham jail, then we know. And all the actions of the civil rights movement were essentially civil disobedience. Thoreau says we should all spend the night in jail for civil disobedience for some effective cause. So when I hear things like be in Fasso's face, and then everybody tells me to call his phone number, which I've done several times and been to his office, and I realize how ineffective it is.
Right.
So I think we also, as a group, need to start thinking a little bit outside the box. I was a NYSA member in the New York State Nurses Association at Vassar as a nurse, and we have annual meetings. Well, one of our annual meetings is disrupted by a handful of protesters protesting for what was called the Home Care Act. And they actually drove vans up to the offices the night before our convention, got out with their drums, and created civil disobedience. Police came, all that stuff. The next day, the New York State Nurses Association closed down the convention because of a handful of people. Real effective civil disobedience. So, the day of the convention, I followed that same group to their rally and saw how passionate they were and talked to them a little bit and tried to understand why they were protesting me, a union member, and I'm a nurse and I'm doing good, right? Why are they protesting me? And really got into their argument and started to realize that their law was probably a pretty good one for people. So a couple different things there. One is that I think we need to start looking at civil disobedience in very select, directed ways. That doesn't mean violence. Civil disobedience has nothing to do with violence, but ways that are disruptive. I don't know what those ways are yet, but calling Fasso on the phone doesn't make him uncomfortable. Having town hall meetings doesn't make him uncomfortable, but something does. And we have to find out what that is that does, and that's what we need to do. And so I'm just throwing that out there from my days in Occupy Wall Street about what was really effective. And again, with that Nurses Association meeting, what's really effective? Sometimes small planned civil actions.
That would be a great old meeting.
Yeah, I mean, ACT UP comes to mind too.
No, ACT UP is the godfathers of it.
Yeah, and Lesbian Avengers has a great civil disobedience handbook. So.
Yeah, I mean, I think that's right, and I think movements need both. You need people like, I'm going to pick on George here down here. You need lawyers, right, and you need them to frame legal questions, and you need people, and you need activists to go out and disrupt. And I think the key element of disrupting effectively is to induce shame. Right? The object of the civil rights movement was to reduce shame in the aggressor, and that's the object that I think has got to be at.
And I think on the other hand, it's also humor. It has to be balanced to get the press.
It gets people.
Let's get some more questions.
I just have one more comment, question and a comment. On these proposed initiatives, is there going to be any dialogue on foreign policy, like the expansion of nuclear capabilities in Iran in the future? Because there's a lot of talking about, Nazi Germany, and there's a lot of correlation to what's going on around the world with populism and in our country. And a lot of concern that I have is all important stuff, of course, on the local level, and is if there's a ground war, there's a President Trump too. That's a given. It's very rare in history that we don't, and there's the things in Russia, North Korea. These are hot spots in the world, and they're being tested, and then it's a big concern, I think, that a lot of people have. So I was wondering about, is there going to be any dialogue on initiatives with foreign policy?
You hit on my vulnerable spot, which is to say I study the United States. I have colleagues who study international relations and would be far better at coming in here and saying we got problems. Beyond sort of knowing that we've got issues with North Korea, China, he's certainly put NATO on the defensive, right? There are innumerable hotspots where he could simply screw up and we could be in big trouble. I think there's no question about that. Lenny, you might want to follow up. You might have something to say specifically about that or something else, but I think you're right. You raise these big, not to mention the humanitarian crisis that we're facing around the world. Syria is still a disaster, right, and should sear the moral conscience, in my views, of what's going on there and the lack of leadership that under the Obama administration, and now I don't know what's going on.
I served in the Iraq War, and I got 2 tours, and the second time I noticed that I saw a lot of money funneling in, because I started signing for bills, papers, and it hit me about Halliburton on the top of the bill all the time. And all these guys, they're all businessmen, and incorporating the oil and manufacturing. And I see, I'm not trying to sound like a bleak person, or be down there, but I mean, given the geopolitics right now, there's a huge possibility. It's greater now than ever,
Go ahead.
Small historical point. You're right on a lot of cases, but you might want to ask Lyndon Johnson about what happened when he prosecuted an unpopular war. So when you get enough people against the war, it's not a shoo-in if the president will maintain power. So I think it's a crucial thing is, to keep constantly aware of making it clear that any war that he might try to attempt, you got to make sure it stays unpopular.
I mean, it also gets very complicated, right? Because someone like Trump, can't get credit in the United States because he's actually a terrible business person, right? So where does he get credit? And he gets credit from places like Deutsche Bank, from China, and from Russia. And here he is poking China rather. He's got some weird relationship going on with Russia. So if you follow the dollars, I'm not sure what any of that means either, except to say that I don't know how far. He has a lot of angry language for China, but he's also beholden to China in many respects because of his need for credit. So I don't know. I don't know what all of that means.
One of the things I wanted I think what I hear you saying is, are we going to also be having a conversation on the things that you brought up? And what we're trying to do is break this down and look at as many of the issues as we can to become more informed and educated. From my perspective, one of the situations we're all in is that we haven't been civically engaged in a collective way. I don't know, I've been doing this 10 years and it's a very hard thing to keep going. You have an issue and everybody jumps on the issue and they're with you, and then the issue resolves and people scatter and go back into their homes. So we're trying to change a paradigm here, and bringing people together and to reconnect, and it's not a fast process. It's not as fast as what we're now seeing, which is sort of a collective result of many years of not being engaged civically. So to some degree, the responsibility too, and what helps me, is to take responsibility in the midst of all of this, and it's a lot, but we start with understanding we work in the ways that we are all comfortable in working. Some of you are focused on national politics and you're traveling to DAPL. Some of you are going after FASO. Some of you are going after and building relationships with your council members. It takes us all choosing the thing that we really are passionate about and going to those things and staying with them and following through and keeping a dialogue going. And that's the point of this. And hopefully, as we get going, we're going to come up with new ways to communicate, because this is a brand new process for many of us. So that's the long answer to what you're saying. Will we get there? I hope so. But there's a lot, and my brother is a sergeant in Iraq too. And he was a medic, and I know the stories. It's all, there's so many stories, and finding the silver bullet, so to speak. That's what we do all the time. What's the crux of this? What do we go after? How do we go after it? What is the story? What's the narrative? And how do we stay with it? Because it's an ever-changing thing. You could take a simple issue like in Kingston. You could take none of them are simple. All right, so you can take a complex issue like a shooting range in Midtown. And you start with what's the law say, what's looking at the charter, looking at the laws, and that's where you begin and where the narrative continues. And it's fast-paced, and there's a lot of people working. It's complex, but through these discussions, I think we engage and get more people interested. And the thing is it's a lifetime work. Civics is not something that we just, dilly-dally in, and it's something to newly embody, I think, in our lives as our new partner.
A new political reality.
Yeah.
I just wanted to say that since the election and especially the inauguration, that I have been so livid that it's really been affecting my health. Just depression and feeling impotent. And what you're doing and what this whole group is intending to do is like the first breath of fresh air that I've had since that time, and a ray of hope. And I think this is exactly the perfect way to do it. It's information, it's the Constitution, and law.
Good here.
I have two questions. The first one pertains to Kinderhook. I tried to look up information. I couldn't find anything concerning the proposed ban. And if there is a proposed ban, doesn't that violate the First Amendment's right to assembly? My second question pertains to something I mentioned during the break, which is that when Elliot Spitzer was taken down, he was setting up for a dogfight between the state and Washington over who has the right to regulate Wall Street. And there were some issues there, and that issue never got to the courts because they got rid of him beforehand. So I'm wondering, and I certainly don't know the answer to this. There might be experts in this room who would know if there are ways that we could explore, put pressure on our representatives and on Albany to resurrect that fight, to see if there are ways that we can do something to affect change in certain laws, in connection with, the SEC. I don't know whose side the SEC will be on any of this, but to see if there would be ways to further regulate and muzzle some corporate behavior.
It's interstate commerce. I think pretty clearly SEC has had that jurisdiction for a long time.
But but the reason they took Spitzer down, because he was challenging that, and there had to be, Elliot Spitzer was not going to challenge that with no good reason. And I'm sure that whatever he was challenging was not going to contravene the 1933 or 1934 SEC Acts. So he must have had some standing. That guy was not an idiot.
Well, this raises the other issue. We've got a bunch of progressive attorney generals from New York State, California. They're all getting together, and they are divvying varying responsibilities in terms of trying to figure out how they're going to use resources and attack some of these problematic federal laws. I don't know. I know our Attorney General in New York State.
He's going to be in Newburgh on March 9th.
So that would be a great question to go there and say, look, Spitzer was ready to attack. Are you going to do the same thing? Or to have if it can't be you, to have someone go, or to even send the question to him. That would be a great question to ask. In terms of these protests, like the Timberhook is doing that. We're mistaken to think that we have absolute rights in the United States Constitution. We don't. The only thing we have an absolute right to is due process. And rights can be stripped from you provided you've gone through due process. And in the case of these restrictions on protesting, I don't know if they'll stand constitutional challenge, and I really don't. But they can make the case that it's a time, place, and manner restriction, that it's a restriction on incitement. Somebody else raised the issue, you can't use speech that's inciting speech, right? You can be held accountable for it. And as I read those laws, that's what they're attempting to do. They're attempting to say, you incited people to go out and break a window. And what's worse, in Arizona, they're actually saying if you drive a car to a protest that you're a part of and somebody goes to break a window, we can take your car, right? We can impound it, right? So I think they're over the top, and I think they'll be struck down. But I don't know, right? They are trying to use language just to follow free speech precedent.
So on that note, we're going to have to wrap it up. It's 4:10. However,